Wait,
Yes.
back to mention item number 19, Manu, with consent from the current council for the petitioner.
19.
Yes, hearing matter.
Okay.
Can this be taken up on 21st of April?
21st.
21st.
No.
No.
No objections. Okay. Mr. B. Pangin, Land Council for the respondent.
Yes, that's point number 2.
Respondent number 2 request the matter may be listed on 21st of April, to which Mr.
M. Kambo,
M. Khambo, Land Council appearing on behalf of
petitioner.
the petitioner has no objection. Prayer allowed. List this matter on 21st April. Okay.
Problem.
May I, Lordship?
Yeah.
Lordship, I'd like to mention item number 7. Lordship, here we have to file additional affidavit.
Additional affidavit
Yes.
for on behalf of the petitioner.
Yes, Your Lordship. On behalf of Senior Counsel and
Whether the
Partner.
other side, is there any private respondent here?
Yes, private respondents.
Are they contesting?
Oh, yes.
Criminal petition.
No, no.
It's criminal petition. Okay. Just a minute. Yeah.
No.
Okay.
State respond.
It was allowed
Yes, it's interim. There's an
No, no,
interim,
no.
Your Lordship.
for filing additional affidavit. Whether the respondent has filed any objection.
No.
What additional affidavit? What for?
Your Lordship, I have been instructed to inform the court to file that we have to file additional affidavit.
Additional affidavit in criminal petition for what? Okay. Mr.
Team Eto, Your Lordship.
Land Counsel for the petitioner submits that he may be allowed to file there are more than one party, it appears,
Yes, sir.
and then more than one accused. How many accused persons are there? So,
But 1, 2, 3. Three.
no, but as per the chart sheet, it appears more than one, more than three, more than two. Here you have included the respondent also, the informant, but then it appears there are more than two accused. And the agreement also, is there any stay order here? You obtain instruction first.
Yes.
And what for you want to file additional affidavit? You have to state properly.
Yes, Lordship.
Just a minute, sir. Are you urgent going out? Or else we can take up later. Let us see the record first. We'll pass order. Wait for some time. Okay.
Much obliged.
Item number 1.
May I please, Lord?
Yes,
Your Lordship, this is an application under section 482, BNSS 2023 for granting pre-arrest bail.
pre-arrest bail.
Yes, Your Honor. Your Honor, I have an apprehension that I might be arrested in connection with the Sesusa PS case number.
Okay.
Case number is not given, Your Lordship. I have been frequently called by the concerned police OC of the Sesusa police station
Okay,
that I'm directed me to come before the police station
for what? In connection with
in
which,
connection with the
what offense?
offense has not been communicated properly, Your Lordship.
Okay, but you must have committed some offense?
Your Lordship, as per the information communicated by the OC,
Hmm.
that the complaint that FIR has been lodged against me by my mother on the ground that I have.
You ask your mother?
Yes, Your Lordship.
Ask your mother what complaint?
Your Lordship, I am now admitted at.
Tell your mother you are admitted in hospital. What complaint you have
I
lodged?
am now at Your Lordship. I am not in a position to go. I am now bedridden. I have been admitted in the hospital, Your Lordship, in Hyderabad for a serious third. I am admitted at the hospital Asian Institute of Gastroenterology,
Yes, but
Hyderabad.
get a proper treatment. Why you are worrying about the case, which is no case at all? There is no complaint against you, nothing.
Your Lordship, I have been
No case registered, it appears.
I have been frequently, Your Lordship, threatened by the OC of the.
See, so many people are being called by the police telephonically.
Yes, Your Lordship.
And unless you properly indicate, unless you properly says that, tell the court that you have been asked to appear before the police in connection with this offense, this case, this PS case, then under what the provision?
That
You are asking?
Lordship, he is not complied with the notification, Lordship,
What notification?
or declaration of a criminal entity.
Okay. You have not stated that you are not in.
Nowhere is that much.
Yes, there is a notification. You have nowhere stated.
Your Lordship, actually, I
It's
have,
premature, it appears. Huh?
Your Lordship, there is, Your Lordship, the fact of the case is that there is one land which have been donated to me by my mother
Hmm.
in the year 2024.
24.
The
Okay.
annexure number 4, Your Lordship.
And what did you do with that?
It is the land gifted by my mother
Okay.
to me
Hmm.
in 2024. Annexure number, Your Lordship, annexure 4. And I am, Your Lordship, fighting,
But case has not yet been registered.
but Your Lordship, I have been.
FIR also not filed? Or what?
This has not been, Your Lordship, properly communicated, but I have been threatened,
When it is communicated,
Your Lordship, in page number 22, annexure number 3.
see, based on.
So many, Your Lordship, numbers of missed calls were made by the OCPS, Sejusa. While I am admitting in
Did he
the,
pick up?
yes, I have picked up
Okay,
once.
then what he says?
He said that I was just directed to appear before him. Otherwise,
For what?
for the complaint lodged by his mother
Okay, complaint regarding what?
regarding the
Offense? What was the
offense, Your Lordship, in page number 5, I have further subsequently gifted this land to my sister.
Sister.
Sister,
Sister is also your mother's daughter?
yes, Your Lordship.
Okay, then,
My sister, Your Lordship. On that ground, my mother is and has on wrong impression that I might have sold this land
To
to-
sister.
to sister, and
Okay. What
she has not been paid for that. Your Lordship, the
Are you sure that your sister is your mother's daughter? Or
Your Lordship, she is my Barbie Nabum, Your Lordship. Is a cousin sister.
cousin?
On that wrong impression that I might have sold this land to my sister. Your Lordship, I have a serious health problem of my life-threatening condition. The brother-in-law, that is the husband of my sister, this sister, had helped me during those my ups and downs in my life while getting treatment of my illness, Your Lordship. On love and affection, out of my love and affection, I have gifted this land in favor of my sister. I had an apprehension, I have a doubt that on this regarding this land gift deed only, this case, this FIR might have been lost by my mother, Your Lordship. That's why I had an apprehension that I may be arrested at this stage, Your Lordship.
No, this will be a blanket order.
So, Lordship, registration paper is not the condition precedent, but here the applicant not come with any material material document that which show that there is a imminent Lordship or there is apprehension of his her arrest, Lordship. So, since he is not complied with the notification also, Lordship, this is not maintainable, Lordship.
Your Lordship, FIR is not a condition precedent to file to
In
approach
which
the.
case, then, pre-arrest bail is to be granted. And you have not also stated that you are not involved in any criminal case or no criminal case is pending against you. So that has been made compulsory. It's premature. I'm going to dismiss you. Your case.
On that condition, if this Your Lordship ground, I may be allowed to.
And then
With-
these also, and try to collect now.
I may be allowed to withdraw with
Advocate
liberty
is
to
there.
file.
So ask the police also, what is the case? Just
Your Lordship,
get the number.
police,
There
the
will
police
be a
is
GD
not,
entry, GD entry, and then a section will be there. Okay.
nothing has.
Mr. Titorum,
Kegara, Your Lordship.
sorry. Land Council for K. Jara, Land Council for the petitioner. Praise for allowing him to withdraw this bail petition with liberty to file a press. If so advised. Okay, this
Obliged.
bail application is dismissed with liberty is paid for. Okay.
Obliged.
Item number 2.
Wait, please, Your Lordship.
Yes, yes.
Madam, this is a criminal petition, madam. I would not like to bother your lordships at this stage with the facts of the case and take your lordship through the positions. This was, charges were framed at page 124. This was against 3 persons, madam, all brothers. Under 498A IPC, there is absolutely no material.
Charges page
124,
124.
yes. 498A only.
Okay.
There are 3 persons were charged, my lord.
Hmm.
In respect of 2 minorities, honorable court has already stayed the proceedings. So in
Okay.
any case, there cannot be proceedings against me now.
Okay.
So I pray for a similar order, my lord. At page 125 is the first order. 3 brothers, my lord,
Okay.
126. Further proceedings has already been stayed, madam. Long time back, in fact.
So notice to be issued.
Yes, notice issued and proceedings also may be stayed in respect of petitioner.
Yes.
Same order.
Hard Mr. B. Pang, Land Council for the petition. Also hard Mr. Kini, Then additional PP for the state staff para. By filing this application under section 528 of the VNSS 2023, the petitioner is seeking quashing of the criminal proceeding in GR case number 914
Yes.
2021 arising out of which PS case?
It's Naharlagan PS case, my lord.
Nahalagan PS case number.
Just a moment. Itanagar Women PS case number 151 of 2020.
Okay, Itanagar Women PS case number 151 of 2021, registered under section 498A, capital 354, capital A, within bracket 2, 506, 34 of Indian Penal Code.
At the time of framing of charges, all the other sections were dropped, only 498.
Oh, okay. All other sections have been dropped
Yes, ma'am.
except for 498.
Yes.
Okay. So, 44, the scanned copy of the trial code code. Oh, sorry. Just a minute.
It's already been
Dalani
called, my lord. It must be here, man. It's already called.
Your lordship may take an.
Already called.
matters
It already
together.
called, my lord.
Okay.
This
Dalani
237,
Cons-
230.
for the petitioner submits that in another two criminal petitions,
237
two,
and
being
238,
237, 2025
25 and 238,
and
2025.
238, 2025. Trial court record has already been called for,
Yeah, proceedings have been stopped.
and the proceeding have been stayed. And the further proceeding of the aforementioned GR case has been stayed, started. Issue notice to the respondent, returnable by, and to the respondents only, staff. So, since Ms. Ginny, learned public prosecutor to enter appearance and accept notice on behalf of the state, no formal notice need be issued, staff. Para. The petitioner shall take steps upon the private respondent by speed post as well as by usual process within
3 days.
3 days from today. Start. Para. So this will be listed along with
Yes.
list. Is pray for comma. List is not along with the above two cases. Them. After 3 weeks.
Well,
Okay. Para. Pending production of sorry. In the meantime,
yes.
it is provided that in the meantime, the proceeding of GR case number 914, 2021, under section 498A of the IPC pending before the Court of Judicial Magistrate First Class UPA shall remain suspended. Stop. Suspended in respect of that. They are also
Yes, all
probably
are
clear
suspended.
mention. Okay, in respect of the petitioner. List the matter after 3 weeks.
Well,
The-
all right.
Of
Matter number 3,
May it please, Lordship.
yes.
Lordship, I have been served with a notice under section 35(3) of BNSS without registration of FIR.
Okay.
From the plain reading of section 35(3) of BNSS, an notice to appear before an investigation officer can be issued only after registration of an FIR. May I take Lordship to language of this notice? BNS 35(3),
Yes.
section
35(3).
35 clause 3 BNSS.
Yes.
May I read?
Yes.
The police officer shall, in all cases where the arrest of a person is not required under subsection 1,
Okay.
issue a notice directing a person against whom a reasonable complaint has been made, or a credible information has been received, or a reasonable suspicion exists that he has committed a cognizable offense. Now, it is very important that he has committed a cognizable offense. To appear before him or at such place or as may specified in the notice. So there has to be cognizable offense. Now, in terms of Lalita Kumari's judgment, whenever there is a complaint where it discloses a cognizable offense, then first FIR has to be registered. Only after registration of the FIR, this notice has to be issued.
So where it,
Lordship, may I take to the judgment of this Lalita Kumari, I have already given, parat 83 to 86.
Sarah,
83?
given here,
Yes,
what you have given?
I have submitted. Lion.
Not here. Yes,
Para 83, merit.
para 83.
Yes. In terms of the language in section 154 of the code, the police is duty bound to conduct investigation into a cognizable offense without receiving information about the commission of such offense. If the officer in charge of the police station otherwise suspect that commission of a such offense, the legislative intent is therefore quite clear, that is to ensure that every cognizable offense is promptly investigated in accordance with the law. This being the legal provision, that there is no reason that there should be any discretion or option left with the police to register or not to register the case, an FIR, when the information is given about commission of a cognizable offense. Every cognizable offense must be investigated promptly in accordance with the law, and all information provided under section 154 of the code about commission of the cognizable offense must be registered as an FIR as to initiate an offense. The requirement of 154 of the code is only that the report must disclose the commission of a cognizable offense, and that is sufficient to set the investigation machinery into action. Right, for that, insertion of subsection 3 of section 154 by way of an amendment reveals that the intention of the legislature to ensure that no information of commission of a cognizable offense must be ignored or not acted upon, which will result in an unjustified protection of an alleged offender. So I will skip 85, let's 86. Therefore, conducting an investigation into offense after registration FIR under section 154 of the code is the procedure established by law and thus in conformity with the Article 21 of the Constitution. Accordingly, the right of the accused under Article 21 of the Constitution is protected, and if the FIR is registered first, then investigation is conducted in accordance with the provisions of law. So, Lordship, therefore, meaning thereby that any cognizable offense, if it is there, then it has to be registered, and only after that, a notice is to be issued. So, section 35(3) is only issued when FIR is registered of an cognizable offense.
Let us come again.
Yes,
35(3).
yes,
The
Lordship.
police officer,
Yes, Lord.
you have been issued notice to appear under 35(3).
3, without registration of
What
any
the content, let
FIR.
us see. Notice
Yes.
to appear before IO.
So, now, if we look at the annexure 10, annexure 1, page 10 of my petition also. If we go to plain reading of this notice also, Lordship, here I don't, we cannot make out any cognizable offense, I think.
Yes. So that is why the police officer said in all
Yes.
cases where the arrest of the person is not
Ye-
required.
Yes. So,
So not required under the under subsection
yes, subsection 1.
subsection of this same
Yes.
section.
When arrest
That
is not
the-
required,
is
then
directing
notice
the
is
person
issued.
to appear. So only,
Yes.
this is only just to confirm,
Yes.
just to know the fact that whether the allegation made against you is correct or not.
Yes.
This is not a cognizable offense.
Yes. Not
That is why they have
cognizable.
issued this notice against you.
Yes.
Just to tell, why don't you appear before the police? What is the problem?
Your Honor, I will appear before the police. There is
Yes.
no problem. But what
See, because it will be very difficult, even for appearance before the police. Police is asking you to just appear to confirm. It's not whether it is clear that where the arrest of the person is not required.
Yes.
You are not required to be arrested.
No.
You are not going to be arrested here,
Yes.
even if you appear also. You just have to clarify. So what is the problem?
Lordship,
How the investigation, how the police will investigate if smallest of the small thing, even to give evidence or to give or appear before the IO, even as a witness also, if you file before the High Court, how the investigation will proceed? Just
Lordship,
go and if your presence or your arrest is required under this act or under this section, he will not, he cannot arrest you.
Lordship, I'm not here before this by this anticipatory. I'm here, Lordship, in the criminal petition. Lordship, what I
That's
want
why I'm
from this
saying.
honorable court is that a small direction may be issued that without registration of FIR, the section 35(3) cannot be issued because it will set a precedent to all in other cases also. So
No,
that,
it doesn't say so. It doesn't so. It
Lordship,
doesn't say so.
because
The police officer, kindly read it again. Let us read it again.
yes,
The police officer said, in all
yes, all
cases
cases
where the arrest of the person is
It's not
not
required.
required
yes, Lordship.
under subsection 1. What is subsection 1?
Subject to issue a notice against a whom a reasonable
In the
complaint.
presence of the
Yes.
police officer, a cognizable offense.
Yes.
Okay.
So when cognizable offense is committed, only then this section 35(3) has to be issued. So when there is no cognizable offense, there shouldn't be any notice under section 35(3). So therefore, I will appear, Lordship. In fact, I've been called today at 3 p.m. However, what I want from this petition, Lordship, that from this honorable court is that a direction is to be issued that in a routine manner.
I
under
have
section
no idea
35(3).
what you have understood from this. But then my understanding is that you will not be arrested.
Lordship, that
only-
I'm not in apprehension of my
only-
arrest, Lordship.
That is
That
why,
I'm
what is
not
the
in
problem
apprehension,
appearing before the police and giving clarification?
Lordship, what
Okay.
that's why,
They have issued under this act only.
Lordship, I want this question of this.
In which case then the police can issue without registration of the case?
Without registration of the case, the police
Before
cannot
registration of the
never,
case, in order
can
to
never,
confirm,
never issue notice.
how? See, even in the direction also,
Yes.
so
Notice,
preliminary inquiry,
they may call for clarification.
what do
but-
we call a
But
preliminary
they can,
inquiry?
Lordship, they cannot issue notice under section 35(3) of BNSS. They may call regularly for inquiry that yes, the so and so have
I
made
have,
a complaint.
hmm.
So you
Yes,
come
yes.
and clarify.
Yes,
Then
that is
we
there.
can go.
Just a
But
minute, just a
as
minute.
soon
What is
as-
there?
Lordship,
Ah.
Dear Lordship, in the section 35 of BNSS Lordship, this a B clause I Lordship, it is clearly mentioned that the police officer has reason to believe on the basis of such complaint, information or suspicion that such person has committed the said offense.
of a cognizable
Also,
offense,
dear
not-
Lordship,
not-
and Lordship, before Lordship registering FIR, Lordship, how can we know that it is cognizable or not, Lordship? And Lordship, moreover, Lordship, here, Lordship, in the subclause 3, Lordship, it is also stated that the credible information has been received. Then, Lordship, on the what basis he will be called in the police station, Lordship, if such notice cannot be served, then Lordship, that's why Lordship, notice served is not illegal, Lordship. Because he just has to appear before the PS Lordship. It's not that he is any kind of warrant is issued, Lordship.
See, Mr. Uttam, the challenging
I'm
appears
challenging-
to me is a
Yeah.
contradictory because it is rather for you only. If it is a cognizable offense, then notice will not be issued. You will
Only
straight away, we will
merely
be arrested.
information
That's it.
only, Lordship.
You will be arrested only.
No, Lordship,
So
Lordship,
here is a case where your arrest is not required, but
Yes.
police wanted to investigate preliminary inquiry or investigate to confirm about the case. Somebody has lodged complaint against you and want to confirm. This probably is about the lane case.
yes, Lordship.
Hmm. So the
Lordship,
case-
I am not here before this for bail, Lordship.
No, I understand that.
Lordship, I am here because that
So
I
what,
am
what would be the
challenging the
result
no-
if it is quashed? You are not going to appear.
no, I will appear. That is a different issue. Whether I appear or not, that's a different issue, Lordship. But this notice to appear without registration
This is
of
for
a
you. What I could see is this is in favor of you only. Instead of registering it, no, a cognizable case, arresting you, he is giving you an opportunity. He's not going to arrest you also.
no. Lordship, that's why I'm saying that this notice to appear by all the police, by all the police station under section 1(3) is itself is illegal because first FIR has to be registered. Only then notice can be issued. Otherwise, if he calls me on a
Yes.
regular basis, I will go and appear, Lordship.
This is illegal encroachment. Before registering, probably making a preliminary inquiry to register as a cognizable offense or not.
Lordship,
That is why
if tomorrow somebody comes and just give a complaint, and if police keep on issuing this notice to each and every individual, there has to be some authenticity of the complaint also. How each and every time a police will keep on issuing this
so you
section
want
and-
you want that you should be arrested. Register under cognizable offense and arrested.
No, no, Lordship. Even if it is, even this, if this, what we can see from this petition, from this notice, even if it is registered, it won't be a non-bailable section, Lordship, first thing. Even if it is registered, it won't be a non-bailable section. What I'm trying to say is that, Lordship, if any person keep on sending complaint to police station just to harass, and the police keep on issuing all this kind of notices, then tomorrow also I have apprehension that they will give us a false
On
case.
the
and it will-
contrary, what I can see is that there is any person XYZ complaint against anybody
Yes.
supposing for illegal construction, illegal encroachment. Police, if straight away arrest, then it will be problem for the society. Here is the case
Yes.
where the police has just called you to confirm the case, if there is a genuine complaint against you or not. And now you are struggling. Now you are protesting against such calling.
Yes,
will be
that's
difficult,
why
Raja.
Lalita Kumari Lordship case said there should be,
Lalita Kumar, what it says?
there
says
should
that,
be,
no-
there
no
should be
notice
first
can be issued.
registration of FIR. only
Let us
then-
see where it says. No notice can be issued.
No, Lordship.
Hmm.
Yes, this 86 that conducting a investigation into offense after registration of the FIR is the procedure established of law. Meaning thereby this section notice to appear is a conducting investigation. Thus, in the conformity with the Article 21 of the Constitution, the right of the accused under Article 21 of the Constitution is protected If FIR is registered first, Lordship, and then investigation is conducted in accordance with the provision of law. Now, section 35(3) is the provision of law. Now, when I'm protected, how I'm protected?
Okay.
Perhaps
So, just a minute. See,
Lordship.
sometimes it happens that the case which was not actually should have been the case being aggravated by the conduct of the parties. And normally it is suggested by the probably the, it happens generally sometime. The instead of cooperating, instead of telling the police straight away that this is simple way, this is not a case, I did not do, or this is my land. And I'm directly challenging that the notice was illegal. Then you see, you are creating some creating the situation where the IO is being aggravated, it appears.
No, Lord.
And then,
He is straight away here filed, given me this notice.
what is the problem, supposing?
No, today I'm going to appear at 3 p.m. IO called me, I'm going to appear, that I have no apprehension of being arrested, Lordship.
That is why.
That is
Then-
why, but
Then why you are appearing,
no.
why you should appear?
What, Lordship, what I mean to say is, for small issues, even if the police keep
You
on
want that
calling,
for small issues, a person should straight away be registered under cognizable offense and arrest.
no, Lordship, Lordship, I want other
There-
way
there
around.
police-
For
police
small
following-
issues also,
according to-
police should not take cognizance or issue such kind of notice.
Oh,
They-
Land Council, this is what I feel.
Without-
This is
without-
in your
without-
favor only. The police is issuing this notice in your favor only.
That I agree, Lordship.
Then,
Now, what I want from this honorable court is that a direction issued to all the police station that without registration of the cognizable offense, no notice should be issued, Lordship.
Lordship,
How that
35
can
3
be?
Lordship, we'll go once more, Lordship. Once again, Lordship, 35 3 Lordship. The police officer shall in all cases where the arrest of a person is not required under
See.
subsection 1, issue a notice directing the person against whom a reasonable complaint has been made or Lordship, or credible information has been received, or a reasonable suspicion exists that he has committed a cognizable offense. Lordship. This or Lordship, that means Lordship, credible information, Lordship.
So
It's not required that Lordship, it is cognizable or not, Lordship. But credible information also, that means it's required, Lordship, to issue this this notice, Lordship, under section 35 3 Lordship. So there's nothing fault in issuing 35 3 Lordship. So he can just appear before the IO and just give him the information what they have required, Lordship. It's not necessary that he has been arrested. He will be arrested, Lordship.
even Lordship, this affair is registered, I won't be
This-
arrested. It will be a non-bailable offense, Lordship. That is not my concern, Lordship.
This is merely, Lordship,
Lordship,
as
what-
information, Lordship.
Yes, information.
Merely, Lordship, for the information, Lordship, this notice can be issued, Lordship.
Where?
You go forward, or you got it.
Yes,
Required.
where has been, where committed, that he has, that, wait to compare that.
okay, so what we'll do is,
Lordship, it can be disposed at the motion stage by the simple direction that if there is no cognizable offense, no section 35(3) of BNSS.
had Mr. Boru, Land Council for the petitioner. Also had Ms. El Hage, Land and Additional PP for the state. Tara. By filing this application under section 528 of the Bharatiya Nagarik Suraksha Sanhita 2023, the petitioner seek quashing of the notice issued by the eye of the case under section 35(3) of the BNSS for his appearance on dated
And moreover, Lordship,
appearance.
the date of appearance is on 11/3, which is already past, Lordship. That's why they have, on the appearance of
Okay,
others, they have
before him
challenging this notice in this hour, Lordship.
on dated 10/3/2026. Stop, huh? Start. It is submitted that based on the written complaint received from one Srimati Benja Yakar, before the police station Itanagar, alleging illegal construction of wall structure by encroaching upon her land and by damaging the retaining wall constructed by her. The police have started inquiring the matter and issued the aforesaid issued the impugned notice under section 35(3) of Bharatiya Nagrik BNSS, directing the petitioner to appear before him on the 11/3/2026 without registering, without registration of the FIR. Stop. Stop. In support of this, it is submitted that without first registering the FIR, the IO could not have issued the impugned notice under section 35(3) BNSS Act 2023. Start. In support of this submission, the petitioner has relied on the decision, of the case in Lalita Kumari versus State of UP 2014 to SEC, reported in 2014 to SEC 1, wherein it is held that it right of the accused under Article 21 is protected if the FIR is registered first, and then the investigation is conducted in accordance with the previous provisions of law. Start. on perusal of the notice. Sorry, just a minute. The section 35 3 of the BNSS states that the officer said, the section 35 BNS read as under, type the 3, page 23. 3. Okay. From the notice, it appears that the petitioner has been directed to appear before the IO in connection with the complaint laws against him for illegal construction. Of a wall structure by encroaching upon her upon the informant's land and by damaging the retaining wall constructed by her. And the matter is under inquiry at the police station. And accordingly, the police station staff and then for the purpose, for the said purpose, the police has directed him to appear to inquire into the matter. Staff, the para. Further, from the perusal of the provision under 35 3 BNSS, it appears that it is understood that it is understood that the police has issued the eye of the case issued. Now, just a minute. The police officer in all cases where the arrest of the person is not required under subsection 1 issue a notice directing the person against whom the reasonable complaint has been made, or credible information has been received, or a reasonable suspicion exists that he has committed a cognizable offense, to appear before him or at such other place as may be specified in the notice. Stop. The notice appears to be the notice is the above notice actually is protection against the arrest. Then it, in the considered opinion of this court, the notice appears to be against actually a protection against the arrest, and challenging it appears to be a contradictory stuff. In view of the above, the in view of the above, the present petition is in the considered opinion of this court is not maintainable. Accordingly, the petition is dismissed. The petitioner is directed to appear before the eye of the case in connection with an eye of the case, and the eye of the case shall proceed with proceed with the case, investigation of the case, investigation stroke inquiry of the case in accordance with law. Stop. Huh? With above this petition stands disposed of. Okay.
Much obliged.
Item number 4.
May I please, my lord?
Yes.
My lord, in this case, I'm aggrieved by the summons issued by the inquiry officer under 179 BNSS without there being any criminal law machinery set into motion, which is a sine qua non and the mandate of law. If my lord may kindly have page number 31, that is the summons.
31.
My lord,
What is that?
summons under section 179 BNSS, my lord. It appears to the undersigned that you are acquainted with the facts, circumstances of Sejusa police station regarding FIR received at PS from Shri so-and-so. You are hereby directed to appear before the undersigned in person on 13/3/2026 at 10:30 hours to give such evidence relating to the instant FIR. Herein fail not, if fails to comply, it will be treated as non-cooperation in police investigation and obstruction of duties, intentionally preventing the service of summons and notice, which falls under section so-and-so, failing which legal action will be taken as per law. There's no FIR number. There's no contents of the allegation. And if my lord may kindly have the BNSS 179. If I may read it.
Yes.
Police officer's power to require attendance of witness. Any police officer making an investigation, my lord, not inquiry, under this chapter may, by order in writing, require the attendance before himself of any person being within the limits of his jurisdiction, his own or any adjoining station, who from the information given or otherwise appears to be acquainted with the facts and circumstances of the case, and such person shall attend as so required. The word which has been used is investigation. So therefore, unless and until there is an investigation or the FIR has been registered, there's no notice under section 179 can be issued by the investigating officer, my lord. And this has been settled by this honorable court as well, and also by some other high courts, my lord. If my lord allows me, I'll just place those authorities.
This, what is this?
Various authorities of the Honorable Supreme Court has also been discussed in this case, my lord. If my lord may kindly have para 14, page number 4.
Yes.
If I may. The next issue is whether summon notice can be issued at the preliminary inquiry stage. It is strict that issuance of summon to witness is governed by section 179 BNSS, section 160 CRPC, which is applicable only during the course of investigation. Section 179 BNSS reads as under. Police power to require attendance of witness. I'll skip this part, madam. Para 16. The above provision makes it clear that the summoning of witness can be done by the police officer only during the process of investigation, and investigation as defined under section 2(1) of BNSS commences only after registration of FIR. Now look para 17. In Ashok Kumar versus so-and-so, the Honorable Supreme Court has held as under. Under the scheme of the court, investigation commences with lodgement of information relating to the commission of offense. The officer in charge has no escape from registering it if the offense mentioned therein is a cognizable offense. Para 18. In HN Rishbud versus State of Delhi, the court explained the steps of investigation as including proceeding of the spot, ascertainment of facts, discovery of arrest of suspected person, collection of evidence by examining person and reducing their statement to writing, formation of opinion and filing of charge sheet. Thus, it is clear that examination of person and recording of their statement by the police officer is a part of investigation under the court. The process of investigation begins only after the registration of FIR, and the purpose is to collect evidence that are admissible in court, bring out the undisclosed facts and build a case which results in submission of the charge sheet. In fact, this court in Prakash Transport versus State of Police has held that summon under section 160 CRPC, now 179 BNSS, can be issued only when investigation is being conducted after an FIR has been registered under section 154 CRPC and the relevant portion is extracted as under. Now, study with my let me have kindly para 24.
Yes.
Accordingly, this court holds as under. Summon notice cannot be issued during preliminary inquiry. The scope of preliminary inquiry is conducted confined to perusal of the complaint and supporting materials furnished by the complaint. If a cognizable offense is disclosed, the police shall register an FIR, forthwith and proceed with investigation. Any inquiry under 173(3) BNS must be completed within 14 days, so and so. Therefore, the mandate of law is that unless and until there is an FIR which has been registered, no notice under 179 BNSS can be issued by the investigating authority.
So the FIR was not registered.
Not at all. There's no mention of the FIR number, the contents of the allegation.
There is FIR.
There's no FIR number, madam.
Hmm?
They say that there's an alleged FIR.
When it was?
Madam, kindly,
12 February.
my lord.
FIR was lodged in the way back in the 12 February.
No, my lord. That FIR which I have enclosed is altogether different, madam.
Hmm? It's not in this case.
No, my lord.
So why you have annexed this?
That FIR, my lord, I have filed it.
Hmm?
No, not me, my lord. There's an allegation against the concerned person whose name is mentioned under 179 BNSS. In respect of some different case.
You are required to appear before the eye of the case. In which case? Don't know.
Page 31, madam.
Okay, this is
There's one person called Virgosh Nabum,
okay.
and against him there was an FIR. And I
Okay,
being an
this is not
officer-
not in connection with the case.
I being the officer, my lord, I have issued a show cause notice. He is the staff. He replied, in retaliation, he has issued a legal notice. And now it appears that there is a complaint which has been filed before the Siju
Oh.
police station.
Against the authority.
These are the offshoots, my lord.
So why you have, by the way, why you have annexed this FIR?
Just to bring on record that, my lord, there was an allegation against the person who has filed this FIR.
And your name is?
Linu Katoman.
Okay.
There was
you
an
got the-
FIR.
Not the informant here. in this
No,
case
I'm not
also.
the informant.
So
There was, my lord, I'm only,
who are you in this case, FIR case,
FIR, I'm no one, my lord.
which has been
I'm
registered?
no one, my lord.
Where you have done annex case?
That's the reason, my lord. There was an FIR against the person. If my lord may kindly have page number 31.
Okay, so this FIR was against the person who has lodged FIR against you.
Yes, my lord. Since I was the officer,
Okay, that FIR is not registered.
not registered, my lord.
Who are you otherwise?
My lord,
Authority against,
authority, my lord. I'm the forester.
okay, and
And
this
He- he-
informant
Staff, my lord. Staff.
staff. You have
Continuous
issued
staff.
a so-called notice
So-
against
so
the staff.
In retaliation, I have received a legal notice, my lord. And then with a threatening that he will be filing an FIR. Now it appears that he has filed this FIR, but has not been registered. Now,
Okay,
police has issued a notice under 179.
so now who is he, you said? In the department?
Virgosh,
No,
Nabam.
what capacity?
I'm a forester, man.
No, the other, one, the
Contingency staff, my lord.
contingent.
Staff, man.
So when you issue so-called notice,
I have received a legal notice, my lord.
you have received legal notice and FIR also.
Yes, man.
Yes,
There were two other cases, Your Lordship, against the DFO and RFO. In previous case, my friend has
against
in the same incident, if I'm not wrong,
against the
Your Lord.
DFO also.
The
But
FIR
then the DFO has
the
got the
FIR
FIR
you'll-
first.
no, the DFO, Your
No.
Lordship will see that FIR on 12th February, Your Lordship.
Yes.
There were two counter FIRs. One
Okay.
by the person whose there was an allegation of trespass by the DFO and the RFO and his other public servants, Your Lordship.
Okay.
That FIR, in that FIR, there was a preliminary inquiry made, and then that FIR was registered subsequently, Your Lordship. Subsequently, this FIR by the DFO, RFO, and the other persons were also registered, Your Lordship.
Okay.
Now, I'm not aware because it seems that the person, the petitioner's name is not even in this FIR, Your Lordship. Now, there seems to be an issue where he has, if Your Lordship will come to page number 27, Your Lordship. There has been an allegation to which this show cause notice was issued to the respondent Virgesh
Virgesh.
Nabam, Your Lordship.
Uh-huh.
If Your Lordship will see the so cause notice that, if I may read, Your Lordship,
Mhm.
where it has been brought that on dated 11/2/26, you were absent from your assigned Duna Nala came during duty hours. It has come to my notice that you have acted negligently in your assigned duty and have been found absent from the camp in the stated day. Whereas you did not inform or reported me camp in charge. He's the camp in charge petitioner. Regarding the reason of your absence and left the camp without obtaining prior written approval. Moreover, a video circulating shows you misbehaving with Srimati so-and-so RFO, territory range and territory staff during duty hour. Therefore, you are hereby issued a so-called notice concerning your absence from the camp and unprofessional behavior towards the forest department. You have to explain disciplinary proceedings should not be initiated against you for the aforesaid reason. So this so-called notice was issued by the petitioner to the respondent herein, Your Lordship. Now subsequently, wide legal notice dated 26/2/2026, Your Lordship will find in next page. The accused has again issued a legal notice to his
Authority.
camp in charge, Your Lordship. Now, if Your Lordship will see that it seems the legal notice on the previous at page number 27 speaks about an incident that occurred on 11/2/26, Your Lordship.
It's a bad idea.
Page number 27, Your Lordship will see.
Yes.
In the first line, it seems that they are speaking about an incident that had occurred on 11/2/26. And subsequently, the impugn summon that has been issued at page number 31, Your Lordship will see it was issued on 11/3/26, Your Lordship. Now, we are not aware of which case, if the case has been registered.
But why these police are not mentioning in almost in earlier case also?
As per my understanding, Your Lordship, there might be a procedure lapses on the part of mentioning the
There's a procedure
sections.
left.
Mentioning the section, but then Your Lordship will see down below the name of the ASI and it's written
Name of
as
the,
ASI
yes,
and then it's written inquiry officer. He probably he's making a preliminary inquiry because
inquiry officer.
if it was someone under during the after the registration of the
But
FIR,
the
it would
notice
have
was
been
issued under 179.
yes. I completely agree to that, Your Lordship. Your Lordship, if I may pray, Your Lordship, because there is no, there is nothing as, even I concede with my learned friend that 179 is more particularly for the investigation, that is
yes,
after the
investigation.
registration of the FIR.
Hmm.
So there, as I have already stated, Your Lordship, there might be an procedure lapse on the part of the police, Your Lordship. If Your Lordship quash this particular summon order, however, if I may pray, Your Lordship, make a further record the further thing that the if the FIR is not registered, or if the police is making an preliminary inquiry, the same has to done as per the provision of law, Your Lordship.
Okay. But they have mentioned inquiry.
Yes, it's an inquiry officer. Otherwise, if it was an investigation, Your Lordship, it would be
Should have been.
investigation officer.
But then the case appears to be in investigation in connection with the.
Yes.
But
Only
then-
the provision under 179 reflected in the summon is wrong.
Hmm.
It would have been a notice of calling upon them for preliminary.
Hmm.
My lord,
Respondent number 1. Oh, there is a private respondent also.
private respondent by name, I have made him the party, my lord.
Yes. Okay.
Notice may not be required, my lord, since this is only issue with respect of law only, my lord.
So who is this?
The
Three is also.
The
Yes, ma'am.
officer in charge as well as the
ASI.
ASI who is making the inquiry.
What do we do with that then?
Your Lordship, I'll be representing because though it's
Okay.
it's
Or
by name, but
respondent number 1, 2, and 3. Okay. This application filed under section 528 of the Bharatiya Nagrik Suraksha Sanhita 20.
Your Lordship, a small prayer, Your Lordship.
Yeah.
Instead of disposing this matter today, Your Lordship may
Okay.
call for the
Then
report
you,
if any.
you
because-
obtain instruction and
because-
produce a record
Yes,
there.
because there is a reference of regarding an FIR. There might be an FIR
Okay. Okay.
also not aware.
Under section 7. 5 to 8 of the Bharatiya Nagrik Suraksha Sanhita 2023. Praying for quashing and setting aside of the police summon dated 11/3/2026 issued under section 179 of Bharatiya Nagrik Suraksha Sanhita 2023. Start, huh? Para.
My lord may call for the records in respect of the summon issued under 179 BNSS.
Hmm. It is submitted that the impugn summon does not disclose the police station case number, nor the provision of law under which any case has allegedly been registered. Start. And in absence of disclosure of any registered case, the exercise of power under section, the issuance of summon under section 179 BNSS without jurisdiction and contrary to law. Issue notice. Since Ms. Jean appeared and accepted notice on behalf of the respondents, no formal notice need be issued. However, she shall produce the case diary. She however, is prayed for, she is given when?
23rd, your lordship.
Okay,
Third would be, my lord,
okay.
bit
She is
difficult.
allowed to obtain instruction and to produce the case diary.
25, my lord.
25, I'm out of
Otherwise,
session.
24,
24, I'll be,
Staff, as prayed for, list is matter on
24, my lord.
24, your lordship.
24,
I have some difficulties.
Okay,
23rd,
when?
it
23rd.
is,
Okay. Okay. This is
Till then, my
on
lord,
30th.
someone may be kept in abeyance, my lord.
Okay. So someone, when you were asked to appear,
the date has already gone by.
No, my lord,
Okay.
but down below, if my lord may see, failing which legal action will be taken as per law.
This date.
okay. In the meantime, it is provided that person to the summon dated 11/3/2026. No coercive action shall be taken against the petitioner. Okay.
Grateful, my lord.
This-
Till the next returnable date. Huh?
Item number 5,
May I please, my lord?
Yes.
My lord, this is joint petition by wife and husband, my lord, for quashing of proceedings in respect of her GR case number 31 of 2022 in connection with 0 Oman police case 03 of 2022 under section 498A 506 and 323. My lord, both the petitioner have settled their dispute, my lord, but by settlement agreement, my lord, 23 August 2025, my lord, page 43, my lord. Annex 5, page 43, my lord.
Oh, what stage the trial is?
313, my lord.
Last stage.
My lord,
When the next date is fixed?
19th of this month, my lord.
19.
That type of case, even after the conviction, can be quashed, my lord.
Okay. Yes, there is a settlement, it appears.
Yes,
There is
So-
a matrimonial issue only, lordship.
Oh, so,
and appellate stage also can be quashed, my lord. My lord, may I start from it's a small judgment, my lord. Apex court, my lord.
Yeah.
Para 3. Para 3, my lord. It may be stated that the outset that on a written complaint from the respondent number here in case number so and so, PS Durgapur was registered under section so and so of the Penal Code and section 3 and 4 of the Dowry Prohibition Act 1960 against the appellant. In the aforesaid complaint, all the allegations against the appellants are that they demanded dowry from respondent number 2 and on non-fulfillment demand respondent number was assaulted and tortured by them. After completion of the investigation, charge sheet was filed in the court against the appellant for aforesaid offences and charges were filed. The London Judicial Magistrate wide order dated so and so found the appellant guilty of the offence under section so and so on so and so found the appellant IPC directed appellant one to undergo rigorous imprisonment for 1 year and simple imprisonment for 6 months to the appellant and prover and acquitted them for the other offence. Being aggrieved, the appellant filed appeal before the session court, which was dismissed by the order as well.
It is worthy to mention that during the pendency of the appeal before the session court, the appellants and respondent to arrive at the compromise, and accordingly memorandum of understanding number so and so was executed on the basis of which a mutual divorce under section so and so of Special Marriage Act was granted by the additional district judge Durgapur in suit number so and so. The dismissal of the appeal was challenged by the filing revision application before the High Court. The High Court, by interim order written so and so, concurred with the finding of session court and dismissed the revision petition. As per the appellants, the parties have settled the matter as they have decided to keep harmony between them to enable them to live with peace and love. The compromise record that responded to have no grievances whatsoever against the appellant and want both the appellant to get acquitted from the case. Further, both the parties have undertaken not to indulge in any litigation against each other and withdraw all the complaints pending between them before the court. In appropriate circumstances and going by the spirit of the law laid down by this court in PS Joshi versus State of Haryana, we are of opinion that High Court should have accepted the settlement and compounded the offense. It is more so when the settlement between the parties who were husband and wife was even acted upon as the parties took mutual divorce on that basis. We accordingly allowed this appeal and set aside the order of conviction passed against the appellants.
Okay.
No, sir, I have no objection. No, sir. I have no objection. No, sir.
No objection. Yeah, why have been asked then? Chairman to agreement.
Yes.
Okay. Record also not necessary to call for.
Not necessarily.
Not necessary, lordship, because lordship, this only lordship, mutually lordship, they have settled the dispute.
There
Lordship.
was my lord, even maintenance case was there. Basis of this agreement, they have withdrawn the maintenance case also, my lord, page 41, this is the word of my lord.
Okay. They've withdrawn this also.
Yes,
This was, okay, 25.
Yeah.
Where is the next date fixed?
19th of this month, my lord.
No, where have you,
Yes, my lord.
the last order, have you annexed?
No, last order, I've not annexed.
Have you stated somewhere?
Yes, my lord.
Where?
Paratli, my lord. So, and Sam had been registered as on and tried at the state of examination accused under P1P CRPC from 19 March on 26.
In March. Today is
It is 16. Yes, my lord, our bench, this was also similar situation of case has been quashed and set aside. So I was the one of the council,
okay.
one of the motion state segment.
Hmm.
Citing this presence, my lord, yes.
Hmm. Three one three stays.
Yes, please. No, it's settled, my lord, in such type of case, my lord, you're not convicted.
No problem. Okay. Where is the settlement?
Yes,
Okay.
43, my lord.
Is 43. Okay, so they decided to separate,
Yes, ma'am.
and then the property given to the wife,
Yes, wife and 4 children.
25,000, 10,000, and maintenance 15,000,
Yes.
and also the expenses of the children,
Yes, ma'am.
maintenance. Okay. Mr. Ketari, Land Council for the petitioner. It's so hard. Yes, Alhage, Land additional PP for the state. Papa. Para. This application under section 528 of the Bharatiya Nagarik Suraksha Sanhita BNSS 2023 has been filed jointly by the informant wife and the accused husband, praying for setting aside and quashing of the GR case number 31/2022 arising out of 0 WPS case number 03/2022 under section 498A 506323 Indian Penal Code, which is pending before the Lanet Court of Chief Judicial Magistrate 0. Stop. Para. The case leading to the filing of this petition is in brief is stated in brief is that based on the written first information report lodged by no, just a minute. Who is the petitioner number 1 is?
Husband.
Okay. The next para would be the petitioner number 1 is the accused husband, and the petitioner number 2 is the informant wife, in the above GR case arising out of the women PS case. Stop. Para. Then the case of the petitioners leading to the filing of this criminal petition is that on 5/6/2022, the petitioner number 2 wife lodged first information report before the 0 Women's Police Station alleging the petition number 2 of rude behavior, giving mental, physical, and financial harassment and causing and assaulting her, causing injury, leading to the registration of the aforesaid 0 PS case number 01 NPS case number 03/2022 under section 498A 506 323 IPC. Staff. Upon completion of the investigation, the police has submitted the case into charge sheet against the accused accused husband, petitioner number 1. Under section, or under the said section, stop. Thereafter, a charge was framed and trial proceeded before the Adjournment Court of Chief Judicial Magistrate, and the next date of the case is fixed on
19th, madam.
19/3/2026. But then it appears that the agreement was entered prior to that,
Yes, prior to that.
but why you did not? This was brought to the notice of the court.
Yes, madam.
Okay, any order passed by the court?
No, madam. Court simply suggested
Okay.
that court cannot compound the case because
Yes, yes, okay.
Mm.
However, however, during the pendency of the trial, the parties being wife and husband has mutually settled their disputes and executed a settlement agreement dated 23/8/2025. Start. Whereby it is stated that due to incompatibility and irreconcilability of the disputes, the wife and husband has decided to. Where have you stated that you are?
para 6, madam. To tell the matter as we get to keep harmony between them, then we need peace, and there no.
Okay. Where have you stated that they are going to stay separately?
Yes, now they are living separately and peacefully, madam. Para 6.
Oh, okay. Separately then, okay. And with a view to live in harmony between the parties and for the welfare of their children. Dispute have amicably been settled with certain terms and conditions, including that the petitioner number 1 husband bequeathing immovable properties mentioned in the settlement apart from payment of apart from maintaining the children for their education. Stop, huh? It is further submitted that after amicable settlement of the case, the respondent number 2 wife has also withdrawn the maintenance case against the petitioner, husband petitioner number 1, and has clearly expressed that she does not want to pursue with the matter any further. Clearly states that she has no further grievance against the accused husband and does not want to pursue with the matter any further. Start. Huh? Para. It is submitted that since the matter has amicably been settled between the wife and husband, there is no scope of any scope of conviction of the accused petitioner, and under the circumstances, the further proceeding of the case against the accused petitioner would be a futile effort and would cause unnecessary harassment, which would amount to an abuse of the process of law. Staff. That according to the Adjournment Counsel for the petitioner prays for passing and setting aside of the proceeding in GR case number 31 stop 2022 pending before the court of the Chief Judicial Magistrate 0 stop Para. Ms. Elhagen, Lane additional PP. Clearly submitted that since the matter is between the wife and husband, and wife and husband, and since the dispute had amicably been settled between the parties, and the wife has expressed that, wife informant has expressed that she has no further grievance and does not want to pursue with the matter any further, she has no objection if the prayer of the petitioner is allowed. Okay, the rest I'll dictate.
Okay.
Item number 6.
May I please, Lordship?
Yes.
Lordship, this petition is filed under 528 BNSS, praying for quashing of GR number 113
oblique 2022 and the FIR being Kambak PS case number 14 oblique 2022. Lordship, petitioner number 1 and 2 are the accused person and petitioner number 3 is the complainant.
One is
Lordship,
accused. And who is,
1 and 2 are the accused and
1 and 2 are accused.
yes, Lordship, and petitioner number 3 is the complainant. The brief fact of the case is that, Lordship, in the year 2022, a student election was held at Doni Polo Government College, Kamkir, West Siang District. During the election, petitioner number 1 and 2 were supporting one candidate contesting for the post of General Secretary. On the other hand, the complainant, petitioner number 3, was supporting another contesting candidate for the same post, Lordship.
So how many accused persons were there?
2 accused persons, Lordship. Petitioner number 1 and 2. Lordship, on the
Offense is under section 448.
448, 354B and 506.
Which
Lordship.
one is non-compoundable?
354B is
What is 354B?
assault to a woman with intent to disrobe, Lordship.
Okay, what happened thereafter?
On dated 20 September 2022, Lordship, due to the misunderstanding during the election campaign,
Okay, then
argument took
what happened thereafter? Whether the
FIR was
police-
lodged. Lordship, kindly see page
police
number.
investigated, charge is filed.
Yes, Lordship, charge
Charge is filed.
sheet is
filed
already
under-
submitted on 13th December 2024, Lordship.
Filed
and-
under what provision? What?
I have annexed the last order at page number 65, Lordship. Next date it fixed on 23 April 2026 for CC.
How many accused persons have been charge sheeted?
2 accused persons, Lordship.
Okay, namely Mija
Mija Gamlin,
and
Bomken Likar. Bomken Likar and Mija Gamlin, Lordship.
Bomken Likar. Mija Gamlin. Okay, then what happened?
Then, Lordship,
Now, next date is, where is the last order? Have you?
page number 65, Lordship.
Page 65.
It is fixed for CC, Lordship. On 20,
When the FIR was filed?
FIR was filed on 21 September 2022.
22.
Yes, Lordship.
Where is the agreement?
Page number 66, Lordship.
What the agreement says?
May I read, Lordship?
Let's see.
Page number 67, Lordship. Second para. Whereas an FIR bearing number 14/2022 under section 448,
Okay.
354B, 506/34 IPC was
Question.
registered against the second party on the complaint lodged by the first party. The police subsequently submitted charge sheet number GR number 113/2022, and the case is presently pending before CJM Alo, West Siang District at CC stage. And whereas due to the intervention, mediation and efforts of the family members, elders and respected
Which
persons of
court it is?
CJM Alo, Lordship.
Hello.
Yes, Lordship.
Okay, yes, yes.
Lordship, since the Lordship, this next date on 23 for 26 and for the CC Lordship, on 60 it can be altered also Lordship. So Lordship, till that time, it may be stay and the call for the case, this.
So if it's stay then at CC, how it can be altered?
Also, because Lordship, CC Lordship somewhere, because this is one section is for the Lordship, non-compatible Lordship. At that time, Lordship, it may be Lordship compatible also Lordship. Because CC state is consider some charges Lordship. It can be look into Lordship whether the charges frame can be.
23/4.
Yes, Lordship. Till that time, it may be state and call for the Lordship trial court record, Lordship.
No, if we stay, then CC cannot proceed.
But then,
The
Lordship.
case cannot
Yes,
proceed
Lordship.
for
Then,
examining
Lordship.
of charge
Yes, Lordship.
if we stay.
Yes, Lordship. Otherwise, Lordship, there's a pity issue, Lordship, that it can be quashed also, Lordship, no issue, Lordship.
Okay. Who is, okay, hard, Mr. So-and-so, huh? Mr.
G number, Lordship.
Planning Council for the petitioner, also had Ms. El Hadi, planning additional PP for the state staff, huh? Reducing it of the back, huh? This application under section 528 of the Bharatiya Nagrik Suraksha Sanhita, BNSS 2023. Has been jointly filed by the petitioners and then filed by the who are the accused? Okay, 1 and 2 are accused.
Petitioner 1 and 2 are the accused person.
Accused petitioner number 1 and 2, and informant petitioner number 3. Praying for quashing of the GR case number 113/2022 arising out of Kamba GS case number 14/2022 under section 448, 354B, 506/34 IPC. Stop, huh? The petitioner number 1, para, huh? The petitioner number 1 and 2 are the accused in the aforesaid GR case number 113/2023. And then petitioner number 1 and 2 are the accused, and the petitioner number 3 is the informant in the aforesaid GR case number 113/2022. Arising out of Kamba PS case number 14/2022. Stop, huh? Para. Where is the FIR you said?
Page number 20, Lordship.
220. Okay, just a minute. And where is the charge sheet? When the charge sheet was
Page
filed,
number 26 to 65 is the charge sheet. Lordship.
where is the date of filing charge sheet? Okay, yes, okay. And where is the, this is last date. And the settlement. Good one. Last, the rest I'll dictate. Okay, was and set aside. Okay, your submission also will be recorded.
No, sir.
That no objection
No, Lordship.
in view of the amicable settlement
Yes,
between,
Lordship.
between the parties.
And it's not a
since
serious
it's a
offense, Lordship.
petty matters.
Yes,
Okay,
Lordship.
we'll take
Yes, Lordship.
5 minutes rest. Okay, resume after 5 minutes.
Item number 7,
Yes. Additional affidavit. What type of additional affidavit?
And also another affidavit stating that there is no such person.
So what do you mean? the police has not investigated and filed charge sheet just after hearing the name. That will be difficult. That we cannot decide. That will be decided by the trial court then in that case.
Yes, Lordship.
Where? Page,
Then we don't know, Lordship.
now, this court will not certify that there is no accused person by that, by that name. Huh. 2000? What is the name of the? How many total, how many accused persons are there? Okay, but only three. No, only two. One would be the informant. Then you are praying, this is the quashing petition. It will be difficult unless all comes.
Yes, Lordship.
So trial court is helpless. That means
They can be.
not issuing any
warrant
non-bailable
Yes,
also.
Lordship.
Non-bailable issued. Declare absconder.
Mhm.
Which one? Which one? What page? Not an ad. Oh, you want to file this?
Yes.
Okay, that is okay. Let them file.
Okay.
Okay. Whether record was also called for, I think there. There is a record.
Record maybe it is
You
here,
also-
Lordship.
The record is there, it appears. It is a record. You also go through,
Yes, Lordship.
and for consideration, your assistant would be necessary.
Yes, Lordship.
Okay.
Mhm.
Okay. Miss, we go, Lani counsel for the petitioner. Submitted, that she wants to bring, on record certain document regarding the co-accused regarding the so only because they are not there, that is why you are not along with this person. Okay. Now, but you know that he was there at that time.
We just conducted after.
Uh, you were together, but then so people were there, but then probably the name has wrong name. What one? Record the regarding the co-accused involved, co-accused in the co-accused charge sheeted by the police in the
In charge sheet, Lordship, their names are there, Lordship.
yeah, that is there charge sheeted, but then but did never appear
Yes, Lordship.
before the court by way of filing additional affidavit. Start. The prayer is allowed. Come. You file within a week? Okay. Okay, in view of the above, Gao is granted 1 week time to file such affidavit, additional affidavit. Stop. List this matter after 2 weeks. Start. The interim order passed earlier shall continue till the next date of this time.
Apply, Lordship.
Yes.
Item number 18(9).
Hmm. It is 9. Yes.
No, Your Lordship, I have just discussed with the opposite counsel, the petitioner, Your Lordship, B. Taba, Your Lordship. Yes, they had shot his permission also, and he has also left the court, Your Lordship. However, according to him, if Your Lordship take up the matter on 23rd of April, Your Lordship,
Hmm.
because we had agreed to on myself and Mr. T. Tapak had agreed on 23rd of April. However, that was prior to the consent of B. Taba, T. Taba. Subsequently, it was informed to T. Taba, and he won't be available on 23rd of March, Your Lordship. So
Okay,
it's
then you want this matter to be fixed on
23rd of April, Your Lordship.
April.
Yes,
Okay, just
because
after
it was by order, a mention was made for listing of this matter by Mr. T. Tapak, Your Lordship. The learned.
Okay. Okay. Mr. Learned Counsel submits that the leading counsel for the petitioner, Mr. P. Tapa, is unwell, therefore pray for adjournment. Stop. Pray for adjournment, to which the learned additional PP, Ms. Jenny, has no objection. Stop. On the prayer of the parties, on the request of the parties, let this matter be listed on 23rd April.
April, Your Lordship.
Okay.
Listed. Your Lordship, I have a small request, Your Lordship. Since I have a doctor's appointment, Your Lordship, if Lordship take up item number 15, Your Lordship.
Hmm?
Item number 15, Your Lordship.
Item 15.
I just wanted to inform because I have received the message from the council,
Uh.
the junior of Biswajit Prasad, Your Lordship.
Uh-huh.
If I may just read the message, Your Lordship.
Okay.
Good afternoon, so and so. This is Advocate Sanjay Shah from Tinsukia. My senior B. Prasad is the counsel representing respondent number 2 in item number 15. Today he is supposed to appear in VC, but due to sudden demise of his senior colleague of our bar, he is
Okay.
engaged in cremation.
Okay.
As such, today I seek time, Your Lordship.
Okay.
So if this matter be accordingly fixed on some
Who
other.
who is for the petitioner here?
Right.
Okay. So then in that case, okay, Mr. P. Ango, Learned Counsel for the petitioner is present. Miss Jenny, Learned additional PP for the state, inform this court that the Learned Counsel for the respondent number 2, Mr. B. Prasad, who is unable to appear the court due to
this demise of a senior colleague
Okay.
of Tinsukia Bar.
okay, due to demise of his senior colleagues at Tinsukia Bar, therefore pray for adjournment of the matter. Stop. Let's pray for comma. List this matter after 3 weeks.
No, my lord,
When?
maybe tomorrow, coming tomorrow.
Okay, no. He is in
Your
bereavement.
lordship,
He's senior.
delay tactic is not good practice. Your lordship.
Oh my God.
It's a very-
What is this? What is this? You have just heard. His senior colleague says, senior colleague expired, that is why he cannot. And how he will move? He cannot. At least, at least 3-4 days. Next week, we'll take up next week.
24th of March. Lordship.
And if you term this as a delay technique, it will be difficult.
Follow up me to phone line and method may fiction tomorrow.
Next week?
24th of March, Your
Okay.
Lordship. Updated CD may also be called for.
Okay. This is matter on 24th March, on which date land addition PP will produce the updated case study. Okay.
Deeply.
Updated scan copy of case study.
Yes, sir.
Okay.
Deeply.
Item number 10.
My Lordship,
Yes.
Your Lordship, I'm praying for withdrawing this quashing petition. Yes. Your Lordship, due to impendency of this quashing petition,
Okay. You want to withdraw?
yes, Your Lordship, because Your Lordship, Your Lordship, trial has already begun in trial court, and there is a scope of discharge.
Okay. Okay. Mr.
Your Lordship, I on behalf of Titorum,
Mr. Your good name,
Titay.
Learning Council, appearing on behalf of Mr. P. Tarun. Somebody said he has an instruction to withdraw this criminal petition. Yes. Okay, criminal petition, stop, huh? The prayer, sorry, Miss El Hagit, Lana Edison PP has no objection. According the prayer is allowed, this criminal petition is dismissed on as withdrawn. Okay.
Much obliged.
Item number 11.
Okay.
My lord, in the last occasion also, both the parties has advanced their argument extensively.
Okay.
This is a case, my lord, where the village authority has denied to exercise the power empowered to him,
Okay.
empowered to the institution. My lord,
So your prayer is,
for direction,
uh,
issuance of direction to the village or authority to conduct Kava.
okay.
Because they have the jurisdiction.
But then they refuse.
They refuse, not only refuse,
Whether
But
the
suggest-
respondent appeared before them earlier?
yes. They have even responded, they have appeared earlier, they have submitted their written statement.
Submitted written
Yes,
statement. Have you
or-
annexed the written statement?
Yes,
Okay. Page
written statement is at page number 19, lecture 4,
19.
19, yes. This seems to have been filed on 28th August 2025,
Just a minute, huh?
19.
Preliminary objection, come reply to, okay. This is.
Now,
Page respondent number? Sole respondent?
sole respondent.
Okay.
May I read the contents of the reply, my lord?
Yes, that's where.
Uh,
Relevant portion?
Yes, my lord, they are saying that, my lord, in the gift deed, they have never signed, put their signature.
Where?
All these issues has been raised. My lord, may come to page number 20,
Okay.
para 2. The grounds they have taken in this written statement is given in this para 2.
Okay.
The signatures allegedly signed by the judicial magistrate, first class, and myself is inconsistent from page number 1 to 3 of the questionable gift deed,
Okay.
and also in the alleged money received. My signature is clearly forged, rendering the document suspicious and questionable. The year written on the document at the first page of the alleged gift deed also seems to be of double writing and
Okay,
malafidely
okay.
adjusted.
You have, he has touched.
Yes,
That's the
that,
merit of the case.
yes,
Okay.
that my alleged signatures in the gift deed and money received is also inconsistent on being paid a closer attention to the details, clearly reflecting the forgery
Okay,
committed
okay.
by
Now let us see the impugn order.
Now, my lord. Impugn order is at page number 25.
You are agreed by which one?
Yes, my lord. May I read, my lord?
Yes,
From the very beginning, my lord.
from the beginning.
Yes. Sri Tabatem respondent party did not appear at mail location on behalf.
Them is respondent.
Yes, my lord. Sole respondent, my lord. On about said given fixed date and time for the customary court procedure. However, on dated 28th August 2025, preliminary objection reply application of statement was submitted before this customary court by respondent. Witness statement of Sri Puji Tale. All these statements, of course, were taken, but my lord, I am agree by the final, my lord.
No, the witness is of the complainant's side. He's the plaintiff.
Yes,
He is the plaintiff's witness. This Pujitale is.
yes, my lord.
Okay, witness was someone also.
Yes, my lord.
Okay, how many witnesses you actually given? Yeah, you have given?
My lord, only my lord.
No, more than one, I think it's a Techimania also.
Testimony is the petitioner, my lord.
Okay, he's a,
This is,
she is a petitioner.
yes, my lord. Pujamania is the person, my lord, who has witnessed the, my lord. My lord, may kindly see, let us read the statement, my lord. Heard
Yes.
witness statement of Puji Tale, where he made a clarification that Sri Tawatem received sum of rupees 1 lakhs only from
He has
Techimania on
seen.
6 July 2008. At the residence Srimati Techimania is Sector Nahlar. Further, he also stated that they have come to plot verification before giving money to respondent and also made confirmation that give deed dated 6 July 2008
Okay.
is his signature.
See, this
He is the
this
witness to
statement.
that.
Is there any separate statement or this?
No, this much, my lord.
Okay.
This much. And the next
This
statement
was
is
recorded by the village authority, customary court.
yes, my lord.
Okay, this is the final order.
Yes, my lord.
In the final order, they have mentioned.
Yes, my lord.
Okay.
Now, my lord, after as my lord,
Okay, then.
then my lord, that in the year 2008, Sri Tapatem, this is the statement of this Techimania, my lord. Next para, my lord. On non-appear of respondent party, it is found that respondent willfully neglected Kabang mail order of Gamura customary court. However, respondent is informed that this matter be tried before the regular court of competent jurisdiction. After hearing statement of parties present at mail proceeding, having stood for consideration today on the day of 30 August 2025, a customary court delivered the following decisions. Now, these are the decisions, my lord. As per the document evidence of complainant and witness statement, it is confirmed that the respondent had received rupees 1 lakh only from Techimania and become a witness of his late stepfather, late Tabat Tagra, give the agreement and money received. However, since Tabat and respondent remained absent, it is difficult to come into any conclusion, judgment. Therefore, this customary court advised the complainant to take the matter before the regular court of trial. As the respondent is not cooperating the customary court and the respondent has denied all the document evidence submitted in his written statement, it is recommended that the matter be tried before the regular court, civil court of competent jurisdiction at Ethiopia.
So, according to you, this order should not have been passed by the
Yes, my
customary
lord.
court. And then since the customary court has a jurisdiction to try.
Yes,
And once it is started, how many time the customary court has issued notice upon the respondent?
Only one, my lord. This
Only
was the first meeting, my lord. First date fixed for the first
Okay.
mail, my lord. And my lord, in such
Now-
situation, my lord, if any party remain absent, not only the complainant, my lord, respondent, my lord, even if the complainant, after lodging the complaint, remains absent, then the customary court has to serve someone against
3 times.
3 times. My lord.
At the gap of
That is
30
provided in the
days.
law, my lord.
With provision, that is under provision?
Yeah, under provision, my lord.
So 15, 16?
Yes. That is, my lord, AP Civil Court Act, my lord.
That the, my lord will find
Yes.
customer empowerment is also given in 2021. Then my lord. Sorry about that. Effective. My lord,
Hmm.
the 2023, my lord.
Hmm.
AP Civil Court Act, my lord, it was amended in 2023, my lord.
23.
23. Amended in 2023, and the amended section is section 44. And I have the copy, my lord. Now, section 11, my lord.
Amended 22.
Amendment 23, my lord.
23. Assam Frontier or Civil Court?
Assam Procedural, yes, my lord.
11.
11, my lord.
Hmm.
Amendment of section 44, my lord.
Yes.
In the principal regulation, in section 44, after subsection 3, the following subsection shall be inserted. The village authority or the inter-village territorial council or apex council, as the case may be, may pronounce or take expert decision if one of the disputing party does not turn up or remain absent willfully for 3 consecutive times after giving not less than 30 days on each occasion of reasonable opportunity of being heard. So in the Assam Administration of Justice Regulation 90, Amendment 2023, my lord, it has been provided, my lord. Why this section, my lord, the village or authority, my lord, they are given the power to conduct Kaba. And if in the first and second occasions, the party remains absent, then, my lord, there will be third Kaba. If despite the serving of summons for 3 consecutive times, if a party remains absent, then after the expiry of 30 days from the last summon, from the date fixed for Keba, now this customary court will have the power to decide ex parte.
Okay.
Now, in my case, my lord, I had lodged a complaint, my lord. They took cognizance by issuing summons, my lord. And that was responded by the respondent, my lord, as your lordship has seen, by filing written statement, alleging so many things in their written statement. If that be so, my lord, let us for a moment assume that the contention raised in the written statement is correct. But then, my lord, it has to be decided. It has to be placed, raised before the competent court.
The, here in this instant court, the competent court is the customary court, my lord. Despite agitating before the competent court, my lord, they have remained absent. And if in such situation, the customary court ought to have served,
In the first summon, the respondent has filed their written statement.
yes, my lord.
And in the second summon, someone did not.
No, in the very first summon itself, where when the date for the mail was fixed on 30 August, prior to that 30 August, they have filed their written statement on 28 August.
Okay, but then 30.
Now 30 August,
Okay, they filed on 28.
yes, my lord.
Okay, just a minute.
Now, my lord has seen,
25.
my lord has seen that this was the first summon, my lord. In response to that past summon, respondent has filed their written statement 2 days before the date fixed for the mail. That is on 28 August 2025. It's not that they have not responded. It's not that they have not received the summon. They have duly received the summon. Therefore, in response to that summon, they have filed their written statement on 28 August. While the date for the KEVA is fixed on 30. Maybe that, my lord, there was some problem
What is
on the
this?
part of the
This
respondent.
impugn order, how do you term it? It's a ex parte order? Then?
Yes, this is ex parte order, in fact.
Have you said- have you
They
said-
have not administrated, they adjudicate the matter, my lord, the
Okay.
customary court. Of course, some evidence were laid, examined, but on the basis of the evidence laid, my lord,
Okay, directed you.
they have
rather.
not,
Yeah,
my lord,
directed you.
passed the decision, my lord.
Directed you to
Yes,
take the
ma'am.
matter before the regular court.
My contention is that, my lord, yes, even in my favor, the village authority could not have pronounced any judgments against
Okay,
the respondent on the very first date fixed for the KEVA.
So that your prayer is to remit it back to the customary court
Yes,
for
my lord.
decision.
Yes, my lord.
Okay,
So there,
so
my,
since they have a jurisdiction.
yes, my lord.
Yes.
And as per, my lord, section 115, my lord, where it provides this, where, in
Failed-
which
failed
cases,
to failed to exercise the jurisdiction.
yes, my lord, in both, my lord.
Hmm?
The village authority has violated both section provided in section 115 of CPC. That is
Both-
clause A and B has been violated, my lord. My lord,
Okay.
may kindly take up this section 115 of CPC, my lord. My lord, may kindly.
To have exercised jurisdiction not vested, where? Not
To
vested
have
also.
exercised a jurisdiction not vested in it by law. This, my lord, has not been, my lord, followed by the village authority, my lord. Village authority, they are not vested the power to, my lord, transfer the case to this civil court. They do not have the power to direct any of the party to approach civil court. They have to adjudicate the complaint, my lord. They have to have reached to a findings, my lord. Either in favor of the petitioner or in favor of the respondent. But the village authority, they do not do that, my lord. Despite that, my lord, instead, they have exercised a jurisdiction which has not been vested with the institution. They do not have the power, my lord, to direct either of the party to approach the trial court, my lord. When they have the power, have the jurisdiction to adjudicate the matter, if the findings may be, my lord,
This your that way, but they has to come to a
Okay.
conclusion, my lord.
Okay. Anything
Now,
else?
Second, my lord, B also has been violated, my lord.
So not exercise,
Yes,
fail to exercise.
yes, my lord. The
Okay.
power which has been vested to them has not been exercised, my lord.
What, have you filed this authority? What is this?
This is complaint, my lord.
Hmm?
My lord, which one, my lord?
No. You are relying upon, no,
The-
it's not yours.
Not,
Okay, well, are you relying upon any decision? Have you submitted? No,
no, my lord.
it's not by you.
No, not by me, my lord.
Okay, then.
Now, my case is, my lord, very clear and simple, my lord.
Okay. Hmm.
Rest, my lord, the land from where I have, my lord, got the land, my lord. That, my lord, need not to be discussed, my lord. The
Okay.
land, my lord, which was 4,000 square meters,
The
my
fact
lord,
of the case.
it was given
Need
to
not
me.
be. Okay.
This respondent was one of the witness to that instrument. He was paid rupees 1 lakh on behalf of, he received the rupees 1 lakh on behalf of his father.
It's,
So all these are, my lord, the facts, my lord,
he-
leading
he
to
is
my
the
lord,
father. So,
transfer of the property to me, my lord.
okay, so, you paid you paid the consideration amount to the stepfather of the
Yes.
respondent,
Who is the respondent here? He, yes,
father of the respondent.
stepfather of the
The
respondent.
stepfather. So,
The respondent,
but the money was received by the present respondent.
yes, my lord.
Okay, and then
That has
but
been,
he
my lord,
signed as a witness,
he was one of the witness to that
one of the
instrument,
witness,
my lord.
but then receipt was also signed by him.
Yes, my lord. And
was signed by
and
Tagra.
Tagra, yes.
Who is
Because
Taba?
he is the stepfather of the
Stepfather, okay.
respondent, my lord.
Receipt was signed by stepfather, and
Yes,
in
ma'am.
receipt also, whether the present respondent has signed as a witness.
Yes, my lord. Yes, my lord.
Where?
Money receipt, my lord, may kindly. Tabate, my lord, firstly, my lord, give deed, my lord, at page number 50. Witness number 1
Just a minute.
is
Huh.
Tabate,
Page
number
50.
Page 50. This is the gift deed, my lord, where the respondent has stood as
Page
one of the
50 is a
witness.
gift deed.
Yes, my lord.
Okay.
This is the gift deed, my lord. Tabatagra is the donor, my lord. Techimane is the donee.
Taba Tagra, who is Tagra?
He is the stepfather of the respondent, my lord.
Okay.
And in the witness number 1, my lord, this is Tabatem, who is the respondent here, my lord.
Witness?
There were
Tabatem.
yes, my lord. There were 3 witnesses. Tabatem, who is the stepson of the donor, Tabatagra. He was one of the witness, my lord. Witness number
He
1.
is now respondent number, sole
He is
respondent.
not respondent, my lord. Now, my lord, money receipt, next page, my lord. Page number 51.
So Tagra is the stepfather, and then Tem is, okay.
He's the witness in the money receipt, my lord.
Mhm. Now, after this, what he says, you said? He denied. Thereafter, the father expired
Yes, there are.
in the year 2016.
Yes, my lord.
Then
Then, my lord,
the land was not given to you.
no, it was given and he's claiming it back now.
Oh, he's claiming back now.
No.
My lord,
Complaint may be kindly seen. Now they are confused with the boundaries. So therefore they requested for sitting in a market.
Okay, regarding this, okay. So dispute is with regards to the boundary only,
yes, my lord.
not the entire.
Yes, not the enter, my lord.
Okay.
So
And
therefore,
that is involved with the fact.
yes, my lord.
Okay.
Now, therefore, I have requested for demarcation of the land now. Because,
Demarcation
yes,
by the village authority.
yeah, by the village authority.
Okay, yes. Anything?
No, my lord, that is
Okay,
only
that-
my case. But since my lord,
Yes,
my only point is that, my lord.
yes, I've understood.
Yes,
Okay,
ma'am.
yes.
First of all, my lord, kindly take note of, after coming of this Civil Code Act 2021,
Hmm.
the original suit,
Hmm.
the jurisdiction. Suppose like, in the present case, the petitioner is having, two forum, parallel forum. He can approach the village authority
Yeah.
as well as to the
Civil Code.
junior deputy.
Okay,
The pecuniary jurisdiction having up to 10 lakhs
okay.
that can be tried by the
Yes,
junior deputy.
that is true.
So that is available at UK. So what this petitioner did, he lodged the complaint before the village authority.
Hmm.
And complaint is also, my lord, very simple, saying that 2008 I purchased a land. This is not a gift because consideration amount he has taken.
Yes, yes.
2008 he was gifted with some portion of land, 4,000 square meter. But today the area boundary are not very clear. So therefore his approach kindly come to his complaint, my lord. Page 16.
16.
16, my lord. Date is 31/7/2025 to the
Yes.
Kambura Customary Court Model Village Nahalagan.
Yes.
Request for conduct of mail for demarcation determination of gifted land located near helipad Nahalagan.
Hmm.
Respected sir, I propose to the cited subject above I Srimati Techi Manya begs to inform your good authority that in the year 2008 I have purchased a plot of land measuring 4,000 square meter located near helipad sorry Nahalagan from late Taba Tagra. That is the stepfather of this respondent. For a consideration amount of rupees 1 lakhs by executing a gift deed dated 6/7/2008 and a money receipt dated 6/7/2008. That sir, in the gift deed dated 6/7/2008, the area of the plot is shown to be 4,000 square meters. However, it is important to bring it to your knowledge that the actual measurement of the plot does not match with the measurements shown in the scheduled area of the said gift land. 2008, but in 2025, she realized, my lord, that the area is not properly demarcated. That's sir, in this
Just
regard,
only one query, huh? Just one query before that.
Well-
Whether after execution of the sale deed and the payment of the consideration amount, whether the said lane was, the possession of the lane was delivered to the purchaser.
that they have not specified clearly.
Okay. You are under the possession of this land since when?
My lord,
When it was delivered to you? Just a minute. huh?
yes,
Hmm.
it was in the year 2008 itself, my lord.
Paid itself.
Yes, my lord.
And then there was a boundary description.
My lord, since then, my lord, even after the gift deed was made, my lord, they have not shown the proper this about.
But then you were under occupation of.
I was under occupation. Now, my lord, since 2008, my lord, many, my lord, development activities are being carried out in that particular area.
Okay,
So
that involves, of course, with the fact, because now that involves with the fact.
But
What
we are saying, my lord,
Ah.
in our reply, we have said,
That's,
this Taba Tagra,
Hmm.
late stepfather, he was orphan. He does not
Okay.
had any land near the helipad.
no, but then whatever may be, but it was sold and then you were the witness.
No, my lord, my sign,
Okay.
it is forged. That is my reply, my lord.
Okay, anyway, okay, thank
Not
you.
only my sign, it is forged, my lord. Kindly
Okay.
see their document itself.
Okay, anyway, but then,
Those are tribal issues, of course, I
Hmm.
understand that, my lord. Now,
Hmm.
kindly, my lord, take note of that junior division as well as village authority,
Mhm.
they have the concurrent or the
Right.
parallel jurisdiction over the dispute involved in the matter, my lord. What they have done, they have approached before the village authority.
Mhm.
Therefore, I am saying that they also, my lord, I have submitted. When
Yes.
our case is weak, we try before the village authority. It's because they does not
No,
know the nitty-gritties of
Hmm.
making evidences and all. So they have filed here. But when we have filed a reply, my lord, saying that those signatures does not belong to us,
Hmm.
even prima facie in their complaint petition itself, the annexed document, gift deed and give deed, magistrate signatures are different. Then what village authority they have done? They have said, since for this evidence has to be taken. Yes, because
So-
we,
Now, since whatever may be, but since they have already filed complaint before the customary court
my lord,
and it is under trial, so you have also already filed
my lord,
whatever you wanted to say, probably in the written statement you have said.
my lord.
The same thing, if you appear and say it, and then let them decide and appear again, because it appears that in fact,
This is
they
decided.
they may have no case, because after delivery of the possession in the year 2008, now disputing that it is not as per the purchase, as per the measurement which I should have.
Well,
He has a weak case, maybe. You may be a strong case, but then since rightly or wrongly, whatever may be the intention, but then they have already filed. Why don't you participate? Because
my lord,
since
participation,
once the
we have filed a objection,
Hmm.
written statement,
Hmm.
preliminary objection. That has taken into consideration. Now kindly see, my lord, what is the language? Therefore, I am saying appeal is there. How can this revision be maintainable? Kindly see page 25, my lord, their document. Page 25.
no, this probably is it amount to the adjudication of the case?
Adjudication of the case. Kindly see.
No, it
page-
says referring that
Referring is, my lord, something when they have felt that since evidences has to be taken, some
no,
appraisal.
despite of taking some evidence,
Huh.
evidence has not been appreciated while while taking decision.
Kindly come to page 25, my lord.
Hmm.
Why I am saying this is the conclusion of trial.
I think we need to continue.
My lord.
Then we'll continue at 2.
My lord.
Okay. Further. Okay. Yes.
There was, my lord, post at page 25. The decision, the judgment of the village authority.
Hmm.
Page 25.
Yes.
Kindly come to paragraph 1, 2, 3, 4, 5th paragraph.
Yes.
After hearing statement of parties present at main proceeding, having stood for consideration today on the 30th August 2025, as a customary court, delivered the following decision. Now it's the final decision.
That's fine.
As per the documents, evidence of complainant and witness statement, it is to confirm that respondent had received so and so, only proximity so and so, and become a witness of his late stepfather, late so and so. Give deed agreement and money receipt. However, Sri Tabat and respondent remained absent. It is difficult to come into any conclusion judgment.
This.
Therefore, this customary court advised the complainant to take the matter before the regular court of trial, as the respondent is not cooperating the customary court, and the respondent has denied all the documents, evidence submitted in his written statement. It is recommended that the matter be tried before the regular court, civil court, or competent jurisdiction at UPIA, given under Gambura's village authority hand and seal on this 30th day of August 2025.
So in the name of decision, it has not decided anything.
It has not decided rightly or wrongly, taking into consideration the submission of the parties, taking into consideration the preliminary objection that was submitted in the form of written statement. This decision it was given.
But this decision is no decision.
This is, my lord, saying that since, of course, it is not mentioned.
Advise the party to approach.
As
So
because
is this a decision?
as because, my lord, when the signatures, entire documents that, my lord,
Appreciated, but then that, that has not been considered.
my lord, when we have filed the objection, my lord.
Should have
kindly-
been actually yes, either yes or no. But then here is a case where it is advised
My lord,
to
but then
approach the court.
rightly or wrongly, when the matter is decided, because language is very clear, customary court delivered the following decision.
That is there, but then thereafter not decided.
This is the decision, rightly or wrongly, when
Ah.
customary court has decided
Ah.
that the matter should be taken to regular civil court.
Ah.
That is a decision. And when that is a decision, matter ends there.
Now here, can the customary court decide not to decide
Of course, my lord,
or decide
provision which my
decide decide to someone to decide? It's like that only.
my
but in
lord,
this case-
the section 44 which my brother has quoted,
Hmm.
that is may, not shall. Kindly come back to that section 44. So if suppose, my lord, this revision is allowed, my lord, for example,
Hmm.
your lordship will be imposing, compelling the village authority despite not having.
That is why the other day I asked him, can we
Ah.
compel?
That is, my lord.
And
what, my lord, he
but
is
then
not-
now
he-
it seems.
My lord, she is
Ah.
not remediless.
Hmm.
There is a provision of appeal. I am coming to that.
Mhm.
Or else she can approach before a civil court at UPA. Why she only want that she should be, her matter should be taken in the village authority, my lord. Kindly come to 44, my lord.
Hmm.
Amendment of section 44. In the principal regulation in section 44, after subsection 3, the following subsections shall be inserted. The village authority or the inter-village territorial council or apex council, as the case may be. Thereafter, my lord, again, may be, comma, may pronounce or takes expert decision if one of the party does not turn up for or remain absent willfully for 3 consecutive times after giving not less than 30 days on each occasion of reasonable opportunity of being heard. So this is the only one ground that my brother is saying, that customary court is bound to give expert decision. This is may, not shall, my lord. Thereafter, my lord, this revision, kindly see, my lord. Is she remediless, this petitioner? No, my lord. Since I am saying, my lord, the matter ends there as per section 2, subsection 2 of CPC. Even dismissal of a suit, understood that this matter since ends there, this is dismissed with a direction to approach before the civil court, is a decree, my lord. In that situation, what remedy she has, the petitioner has, is the appeal. And section 115 CPC, my lord, clearly says revisional jurisdiction only and only if appeal does not lie. And basically, in our affidavit in opposition, my lord, we are saying that the matter is concluded, and since there is a provision of appeal in AP Civil Code Act 2021, section 15 particularly, so therefore this revision petition is not maintainable. And other than that, my lord, petitioner have other remedies, my lord. Can approach civil court, having the concurrent or parallel jurisdiction over the subject matter, or can file appeal, my lord. Appeal also, if it is filed, the matter will be taken de novo, my lord. Therefore, my lord, these are the issues, my lord, because after coming of this act and amendment of 45 Regulation Act, there are so many ambiguities, my lord, that needs to be corrected. Therefore, that day also I emphasize the lordship, kindly look into such kind of matter and give some proper decision so that matter remains settled in the near future. So that much only, my lord. My submission, respectful submission. One small citation, my lord, that I have placed is that decided by this honorable court in CRP number 13 of 2021. I think the copy is there. Paragraph 8.
13. Yes. There are 8.
Para 8.
Hmm.
This is before coming of 2021 Act, my lord. Section 46(1) of Assam Frontier Regulation Act provides that any person aggrieved by a decision of a village authority may appeal to the Assistant Commissioner in suit not exceeding ₹500 in value and to the Deputy Commissioner in suits exceeding that value. In the instant case, the petitioner, instead of filing an appeal, before the learned Deputy Commissioner West Siang District, Alo, against the decision of KEBA, prepared this revision petition before this court. While there is a specific provision for appeal in the statute, this revision petition, in the considered opinion of this court, is not maintainable. So this was before coming to the effect of Civil Code Act 2021, my lord. Now Civil Code Act 2021, my lord, it has come, and thereafter the amendment 2022, my lord. Wherein subsection 3 of section 15 was
Amendment
amended
2023.
2022, my lord. 2023 is Assam Frontier Regulation Act. 2022.
Twenty-two.
2022, my lord.
Probably the 23 is
3.
23.
No, 2022, my lord. Kindly come to section 3. Amendment of subsection 3 of section 15. Roman 3, my lord.
No, it's 2022.
2022.
But given.
There are 2 amendments after 2021 Act. One is
No, this
2020.
21 is available. 22. Okay, 22. Okay, 22. Yes, 22.
22, my lord. Section
Amendment.
3. Amendment, my lord.
Yes, yes. Yes.
Section 3.
Hmm.
Roman 3, my lord.
Yes.
After the port provision to subsection 3 of section 15, the following subsection shall be inserted. 4. An appeal from the village authority, if agreed to by the parties, shall lie before the inter-village territorial customary court or apex customary court by whatever name called, which shall settle the case as per the local tradition customary laws under the provisions of section 40 of the Assam Frontier Administrative Justice Regulation Board, provided that an appeal against the order of the intra-village territorial court or apex customary court shall lie before the Court of Civil Judge Junior Division, the Court of Civil Judge Senior Division, in the courts of additional district judge or the courts of district judge, as the case may be as per their territorial and pecuniary jurisdiction. So there is a provision, my lord, which the petitioner can avail, my lord.
So according to you, this amounts to the decision.
Decision, my lord. Rightly or wrongly, this is the decision, my lord. Why this is the decision, my lord?
And against the decision, appeal lies.
Appeal lies, my lord. Because language also very clear, my lord. 1, 2, 3, 4, 5, fifth language. After hearing statement of parties present at mail proceeding, having stood for consideration today on the 30th August 2025, as customary court delivered the following decisions, my lord. This is the decision, my lord.
Okay. Yes.
And my lord, kindly taken note of. Petitioner is not remediless, my lord. That may be kindly taken note of. Either she can approach to civil court or she can file appeal. That's all.
Okay.
My lord, as submitted earlier, my lord.
Okay.
My lord, there is, my lord, a violation of section 115, my lord. I have shown the provision, my lord. Section 115, clause A and B, my lord. Either the village authority has not exercised the jurisdiction vested upon them, or by
No,
by
what is submitting is this is decision not to exercise or exercise, but then this amounts to decision. So
no, my lord, to me, my lord,
against the decision, appeal lies. What is he?
my
submitting?
humble understanding is that, my lord, they have just mentioning that this is a decision.
So that is why I'm
cannot be treated as decision because they have not, my lord, adjudicated the matter as per the evidence led, my lord. If at all, my lord, this decision is to be taken as a decision of the mail, my lord, then, my lord, reference of the statement of the evidence has to be taken into account while making the decision.
It
But,
can be
my
ta-
lord,
it
the
can be
findings
taken-
of the,
It can be taken by the appellate court.
no, my lord, in this regard, my lord,
Ah.
my submission is that, my lord, the village level institution, my lord,
Hmm.
who are well vested with the power to adjudicate upon the matter, my lord, they have failed to execute it. That is my first point of submission. And my second point of submission is that they are not, my lord,
Though
they are not
saying that
vested to
they are not
power.
saying that we are not deciding, or we will not decide.
They're gonna say
They
that,
say that we decide.
no, my lord. They have
See,
said
see,
that
see.
we cannot
See,
decide,
the
my
following
lord.
decision,
Because-
deliver the following decision.
My lord, may kindly
Then decision may be what decision, whatever may be the
hereafter,
decision,
my
but then
lord,
they said that it's a
hereafter
decision.
decision, my lord, just mentioning that such decision has been taken.
Hmm.
It has to be based on the evidence led by the parties, my lord.
That
My
is
lord has
discretion.
seen,
That is discretion.
my lord has
Is that
seen.
not the discretion?
No,
Whether
my
that-
lord.
how much of the evidence is to be appreciated? It's a discretion of the concerned court.
That's true, my
Is it
lord.
not?
That's true, my lord.
Hmm.
That's true, my lord. They have led the evidence, my lord. The evidence led in the mail, my lord, all gave statement in my paper, my lord. Supposing, my lord, of course, there are only one evidence. Other statement is from the complainant,
Well,
my lord. But then, my lord,
What the mail says, what the KEBA says, that after considering this, after considering the evidence of your evidence,
they
and
are
the evidence of
expressing their
others, they have
inabilities, my
decided
lord.
this.
My lord,
And then
they are-
according to the learning council for the respondent, this amounts to decision.
no, my lord.
And an appeal lies against the decision,
No, my
such
lord.
decision.
Decision has to be,
This is a final decision.
my lord, it has to be based on the evidence led by the parties, my lord. There is, although the evidence was led, my lord, but their decision does not have any bearing with the, my lord, evidence led in the, my lord, proceeding, my lord.
Now, that's
So
why I'm
therefore,
saying-
my lord,
that's why I'm saying-
therefore, my lord, my submission is that in such a case, my lord, and not this making the decision as per the evidence led by the parties is, my lord, is a violation of, my lord, of section 115, my lord, because they have failed to exercise. Just they have, my lord, if at all the mail decision was made on the basis of the evidence led, and there was a finding whether in favor of the petitioner or in favor of the respondent, then, my lord, that becomes a final, my lord, order, my lord. And more so, my lord, my submission, other part of submission is that, my lord, Civil Judge Junior Division is a appellate court, my lord, as per section 3. My friend has read it out just now, my lord. My lord, may kindly take up the Amendment Act of 2022 once again, my lord.
Hmm. I mean-
The amendment
2000,
2022,
20?
22, my lord. I just,
Okay.
my friend has also referred the section, my lord. My lord, may kindly still to come to page number 2,
Hmm.
Roman 3,
Yes.
and appeal.
Hmm.
My lord, I am saying that, my lord, Civil Judge Junior Division is an appellate court, my lord. They cannot just say in transgression of the provision provided under 115, the village authority could not have advised the party to approach the appellate court without passing any decision, making any decision. My lord, may kindly see an appeal from the village authority, if agreed, of course, this has order has been, my lord, amended, my lord. An appeal from the village authority, if agreed to by the parties, shall lie before the inter-village territory customary court or FX customary court by whatever name called, which shall settle the case as per the local traditional customary law under the provision of section 40 of the Assam Frontier Regulation 1945. Provided that an appeal against the order of the inter-village territorial court or apex customary court shall lie before the court of judge junior division, the court of civil judge senior division, and so and so. Now, my lord, by this amendment, my lord, civil judge junior division has been made as a appellate court, my lord. If party is aggrieved by the decision of village authority, my lord, they can prepare appeal before the civil judge junior division. The village level institution, my lord, without, my lord, adjudicating the matter on the merit, my lord.
Submitting appeal lies. Appeal lies.
My lord, they cannot straightaway send me to the appellate court, my lord.
Yeah.
There has to be some
But
decision.
you are agree by their decision to send. So appeal lies. That is what the
Yes.
respondent submits.
Yes, my lord. But without adjudicating the matter, having adjudicated the matter, they are straightway sending me to approach the appropriate civil court. Saying
But you are aggrieved by
saying that
by the sending.
they are incapable of adjudicating the matter because there is a dispute between the parties. So it is their bounden duty as a civil court, as a court, my lord, lowest court. They have the bounden duty to adjudicate the matter. They have not adjudicated, my lord. They have not at all adjudicated, my lord.
Okay. Anything else? Mr. Amduk, huh? Counsel for the petitioner. Also heard Mr. Ketama, land counsel for the sole respondent. Stuff. Hearing concluded. Judgment reserved.
And my lord, my submission was not concluded. my lord. In fact, my
Not
lord,
concluded?
yeah, yes, sir. One more thing, my
Okay.
lord. My friend was submitting that, my lord, because there is a dispute between the parties, all those documents are disputed, so therefore the village institution could not take up the matter. My lord, even
No, that
it's not that, my lord, village authority cannot lead an evidence, my lord. They can, my lord. They can summon, party has given the opportunity to
that is
produce
what
the witnesses, my lord. To
normally
bring- so,
people used to approach the village authority when they think that their the evidence is not sufficient. That is what he submits.
then, my lord, in that case, they are given the chance to bring more witnesses, my lord. That is the procedure, my lord. That is, my lord, practice in our this customary court, my lord.
If
we can-
pleadings are there, my lord, that may be taken.
We cannot say that, my lord, they are incapable because of the, my lord, inability of the witnesses. They cannot decide. Then, my lord, they are throwing this, my lord, matter to be educated to a court, my lord, which of course they, in fact, my lord, the village authority has to do, my lord, as per the law, my lord, as per the power given to them. And my lord has seen there is a violation of section 15, that is there. Either they have not-
105,
Yes.
15.
Yes,
Okay.
my lord.
Okay. Okay.
Oblige.
Next.
Item number 12.
No, that's me. Trial court record is
Yes.
still awaited.
I wait.
So let the trial court record come.
My lord, we can take up the IA.
What is the IA?
My lord, if your lordship kindly have the last order, CRP 3,
Mhm.
9/2/2026.
Mhm.
My lord, this was hard, in fact, and my lord has passed some order. shall not dispose of the suit, but
So
land.
they-
Yes.
There
There's no
is some
question of
interim
getting the
order.
IN.
He,
Lord,
preventing
because
him
it's
from
urgent matters,
disposing
my
of
lord,
the land,
because-
creating third party interest.
Yes.
Because, my lord, is an urgent matter because they are on the suit land, they are digging, constructing,
No,
they
no,
are
so
altering.
that is why this,
and
probably
shall
on that
suffer
day you did
irreparable
not
loss,
pressurize, but then
which shall
still
not
then
be
this court has passed.
compensated with money.
Just have
my
you
lord.
gone through the order? Just go through the order. Upon hearing the parties and on perusal of the petition, it is provided that the respondent shall not dispose of the suit land creating any third party interest. So he is prevented from disposing of the suit land creating third party interest.
My lord, he
So
is
this is
digging,
interim.
altering,
Hmm?
which shall not be compensated with money, my lord.
Which one?
Is continuing the construction, my lord, on the suit land.
Construction, see, supposing if you, if the case decided in your favor, so they will take risk, it's their own risk. It will be,
My lord,
it
no,
will be with
it
you,
shall
they
not
cannot.
compensate- It will not compensate with money. And how can they compensate me?
How, means,
If they are the judgment debtor,
hmm,
the trial court, I am the title holder, how can they compensate me? They cannot compensate me with money. How can they compensate me? They cannot compensate me with life. Can they?
There is a process, my lord. Your lordship has
My lord, we
ordered
can hear,
record.
hear this,
Let
I-
the records come. And in item number 13, we have not even been served a copy of the petition yet.
okay.
My lord had heard the interim prayer of the last occasion.
Yes, yes, that is.
Your lordship will recall.
Hmm.
How can the interim prayer be heard 2 occasions? My lord may send reminder if necessary.
Okay, the Lana counsel for the, Mr. Lenjing Burton, Lana counsel for the petitioner in person. is
Petitioner in
present.
person.
Hmm?
Petitioner in person, not
Yes,
conference.
petitioner in person.
Yes.
He is present. Mr. Diki Pang, Lana counsel for the respondent is also present. The trial to the court is still awaited. Staff. In view of the above, the registry shall issue reminder for trial court the court. Staff. List this matter. After the trial court record is received.
Right.
Okay. Or trial court record is received. Will say like that. Otherwise, no
my lord,
point.
should be as soon as possible, my lord.
Okay.
Yeah.
So, but then
Because
said
they
that the
are
registry will issue
altering the-
reminder.
They are altering the.
Now the registry will
Yeah.
issue reminder to the trial court to transmit the record.
My fundamental rights is being infringed.
Hmm. Okay, agent, when the
I
record
want the-
comes, we'll decide.
Yes, by next week.
Agent, when the record comes, we'll decide.
Because
We'll
the
take up
report
the
has
matter.
come till
Okay.
not more than one
And
month.
in item 13, what do you say? Copy
We
noted.
will get it from your court's record. I will get it myself. I have not received yet, but
Okay, in the same order, huh? Here also trial court record is waited.
same.
Okay, same order. So then, copy not yet received here. Received.
Yes, I have not received.
Not yet received. You
Yes, I
furnish
have
the copy
instructions.
I had already furnished him the copy and he said he has received the copy.
in the court.
Yeah, no.
No.
When he had filed the caveat, I filed the copy with the court.
I filed a caveat in item number 12 only. I
Caveat
have,
already discharged.
yes.
Okay,
The
then,
case is similar, my lord. The
okay.
petition
Then-
is,
In any
Sir,
case, he
sir,
has to
sir,
serve me a copy, my
Okay,
lord.
and the court
Okay.
also said it's already served. In the order it is passed.
What is this, man? We'll file our Wakaratnama today. In 13.
But then you accepted notice on this, in this.
Yes,
Yes.
I want
And he has
instruction.
to file the Wakalanama.
Okay, okay.
And how can he
Mr.
appear before
Legend
the court
continue.
without Wakalanama?
The petitioner in person and all.
How
also
makes
Mr.
us
Diki Pange,
submissions? We have been practicing over a long time.
Diki Pange, Lana Council for the respondent. Okay. You have not yet filed Wakalatnama?
I filed Wakaratnama.
Okay.
For
For the
the
I was
respondent, who
under
submit, who
instruction.
submits that a copy of the petition has not yet been shared
PRP4 has not filed the Wakalanama.
to him. Stop there. Mr. L. Pertin, the petitioner in person shall furnish a copy of the petition civil revision petition to the learned counsel appearing on behalf of the respondent within 3 days from today. Okay. List is matter. Okay. The trial court record is still awaited. Same record.
Same
Okay.
records.
The registry shall issue reminder for transmitting the trial court record. Staff, list is matter after receipt of the trial court record. Okay.
Problem.
My lord, can we see whether he has filed the Vakalan number in CRP3 versus Babang Ratan? In Babang Ratan's case, CRP3.
CRP3,
CRP4, my lord.
CRP4,
Of
What do you-
2026.
what you want?
I want to see whether he has filed the Vakalat number or not.
Oh, Wakalat Nama?
Yeah, he has yet to file the Vakalat number.
I think this honorable courts, presiding judges of this honorable courts knows me well enough
No,
to
the,
entertain such
they
submissions.
already accepted notice
And I have filed my Wakalat number today, man.
today. Okay.
What is this?
Okay.
Matter number 14.
Yeah.
Thank you, Lordship.
Mhm.
Lordship, item number 14. There is one connected IA which I filed
IA is regarding?
for suspension of the conviction, between judgment and conviction date, conviction.
This appeal?
I'm for the accused person, Your Lordship.
Just a
Victim
minute.
person, Lordship.
If you
Lordship, my only apprehension is that, Lordship,
Record you have received
yes, long back, Your Lordship, and
long back.
yes, and the present appellant, my lord, is in custody for more than 9
Oh,
months.
no, the preparation of paper book is in progress.
Your Lordship, on 2 or 3 occasions, I have approached the registry, my lord,
Mhm.
but they said that it will take some more time, my lord.
It is in progress, they said. So it takes time.
It will, of course, it will take time, but my lord, I'm in custody for more than 9 months, my lord.
9 months. This is conviction case.
Yes, my lord.
Under for
Poxo.
offense? Poxo.
Poxo.
Okay, what is the sentence?
Sentence, my lord, I have been sentenced to 10 lord.
They had sought time for file objection. And they. No, that is.
Not filing.
No, if your lordship sees the last order, if they, if they are not filing, your lordship can fix it for admission hearing. La.
Quashing petition.
Yes, yes.
Okay. Whether the record was called for?
Yes, Lordship, we received the CD, Lordship.
Oh, receive the CD.
Yes. On 21,
Okay.
21 to Lordship.
Then when do we fix this?
Can it be on 5th, Lord,
Okay.
for admission hearing, Lord?
Okay. 5th of
April.
April.
Oh, 6th, my lord. Sorry, I'm sorry, my lord. Again. 6th is working day, my lord.
Mr.
R. Dubey, my lord.
R. Dubey, learned counsel for the petitioner. Also had Mr. Lloyd, learned EP, and Mr. S. K. Deori for the learned counsel for the respondent number. Learned counsel appearing on behalf of the respondent number 2. Okay. Who submits that? Who is not? Earlier, have you made prayer for filing objection?
Yes, on
Submit
last
the
photo.
that the respondent number 2 is not filing any objection.
Ah.
Okay, not filing any objection. It was
My lord may record that they are not
observation.
willing to file any.
Staff in view of the above and as prayed for by the learned counsel for the parties, let this matter be listed on 6th April for admission. Okay.
Well, there is an interim
On-
order which needs to.
The interim order passed earlier shall continue till the next matter of listing. Is case that not yet charge sheeted?
No, no,
This is an initial stage of investigation, my lord.
Okay.
If my friend one, let him appear and reported it, there is no evidence.
Lord,
against
it's
it.
a case of civil dispute, my lord.
My
I'll
lord.
satisfy your lordship.
That's why, my lord, if the police found nothing against him, the police will file FIR against him.
You are not, you did not appear before the police?
No, 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 lord, because I'll demonstrate your lordship that it's a case of civil dispute.
Okay,
And that's why.
so
your
that is
lordship-
why you are not
Yes, yes,
appearing.
my lord.
You don't want to appear.
Yes, my lord. My lord will decide on the merits.
Lordship, on the last two occasions.
Okay.
Notice was issued, Lordship, but
Ah.
it was returned unserved.
Now it's a cognizable.
Yes, yes, cognizable, my lord.
Okay.
In
You-
fact,
you
the-
are protected under, protected? No.
my lord, yes, your lordship was pleased to protect me, my lord, because after a detailed hearing, my lord, I
Okay.
can demonstrate your lordship's my lord, that
Okay.
it's a,
Okay,
my lord.
okay, it's fine. Yeah.
My lord, interim protection till 6th, my lord.
Okay. The interim or the pass earlier shall continue till the next date of this thing, huh? Okay.
I'm deeply obliged.
Matter number 16,
Ah.
say election petition.
On the last occasion, your lordship was pleased to fix calling the
Yes, sir.
official witnesses.
Yes, official witness.
Yeah, we have
So-
already served the notice. Any steps have already been taken. But
They are not appearing.
they are not appearing.
So, so now this court will be there for another 3 weeks.
Yes,
Now you can take proper steps upon them.
yeah, fresh step.
Fresh step. Because it was probably on that day also subject to the, of course, the
Availability of
availability of
court
this
on
court.
this.
So since the court is available for another 3 weeks, so you can take steps and then we, yeah, step for issuance of someone.
May not, may I kindly, my
Yes.
humble request.
Hmm.
My humble submission would be if we are allowed to take through dusty service, because this step has to go to CGM, from CGM will go. So in case if your lordship permit us to go for dusty service.
Whether dusty is allowed.
Because first step they have not appeared. Now second step,
Huh.
because
It is for the witness, my lord, let them take a step through the registry.
in that case, your lordship may.
Whether in election petition,
Step was
dusty is
taken
allowed.
on my lord third.
Hmm?
So it was ordered in earlier. The step was taken on third only, as per the court I have seen.
Third means this
Third
third,
of March.
3rd March.
Yes,
Yes, sir.
And
Yes, sir,
it is
there is
good.
a delay.
then it has gone
There
to
is a
CGM
fault
on
of their
field.
part.
So they all are nearby office only in the capital
In the
region.
capital region.
Maybe, but it has to be.
So,
routed
my lord,
through the-
So probably it has not reached.
20, then may kindly fix on 27th. Good, then in the meantime. we can-
27th.
20.
Is it okay?
My lord, subject to availability of the witness.
Then
Now, let them
this
give
court
a-
will be available.
My lord,
on
let them
27.
give a sufficient time, my lord, because last time also they are.
27 probably is fine if you take steps within 2 days.
My lord, well, we will take my learned friend,
Hmm.
Dr. is here. 27.
My lord, let
27.
it be on Monday, my lord. If it is not over on Monday, then we will continue on 31st also, 30 and 35.
27.
27 is Friday.
Okay, what we'll do is supposing this will be evidence. If they appear, 3 of them
Yes.
appear, then it might take 2 days also.
2 days also.
So then we'll fix it on 30.
30.
At least 30 minutes, maybe fix on 31st, then, because
Huh? No,
Yeah.
31st, then we have 1 also.
Yes,
Okay.
one also. Yes,
31st, no problem.
No problem.
Okay.
so we can continue on.
Sure.
31st, 1, 2.
Hmm.
Yeah.
So, Mr. MG Singh, Learning Counsel for the election petitioner. I've also had Mr. SK Deori, Learning Counsel for the respondent, stroke return candidate. Okay. Para. Why it is not coming on record that steps taken? No, it's there. Oh, this is IA. Okay, where is, okay, in the main it will be available. Okay. In the order part. Now, where is the order sheets? They give me this part, this part. Okay. No, it will be difficult. notice issued to the officer. Okay. In the main election, huh? Where did I? So, let me take. इसको ऊपर मत रखो। ये separate नहीं। Okay. The Land Council for the election petitioner submits that he is taking steps upon the official witnesses on dated 3/3/2026. However, no one appears. This was by usual process.
Usual process.
Whether Dusty can be allowed, Mr. Singh. Can the Dusty in election petition? No,
Normally, it's not.
it has to be through registry. Then we'll not do. No, go for that. In view of the above, the counsel for the petitioner praised for allowing him to take fresh steps upon the official witnesses. For their appearance with their respective original official records on the official record, huh? Stop. Will be for evidence only?
Evidence.
For evidence, huh? Stop. As prayed for, as requested by both the Land Council for. Sorry, the prayer is allowed, huh? Okay. Para, as requested by both the Land Council for the parties. List this matter again on first of no 31st, huh? 31st March. 1st of April because it's on 2nd. 31st, huh? Because after 3 weeks, that will be the first, and then the second will be the last date. It will be a little difficult. 31st March. Stop, huh? Then prayer allowed, huh? Step after prayer allowed, huh? Step by register post.
Register post.
No, not register. It's a speed post only.
Speed post.
Speed post. As well as by usual process within 2 days from today, huh? Okay. Then after that will come, huh? As requested by the Land Council for the party list this matter again on 31st March. Okay.
Apply, sir. Please.
Okay.